honorable ministers, Chairperson of Ministerial, His Excellency Ambassador Chung Hee Han, and the Secretary General for Legal Affairs and UN Legal Counsel, Mr. Miguel de Flores, Excellencies, High Representatives of Signatory States, Excellencies, members of the diplomatic corps, distinguished guests, ladies and gentlemen. It is indeed a great pleasure and honor, as well as a privilege, to welcome you all to the ceremony marking the opening for the signature of the United Nations Convention on Transparency in Treaty-Based Investor-State Arbitration. In short, it is called Mauritius Convention on Transparency. As you are all aware, the Mauritius Convention on Transparency is a new treaty elaborated and approved by the United Nations Commission on International Trade Law, Ministerial, which was adopted by the United Nations General Assembly in December 2014. The Mauritius Convention recognizes the importance of transparency in the settlement of investor-state disputes. We express our sincere thanks to all the high representatives of states who have responded positively to our invitation to attend this important event. Let me take you briefly through our program of today. Today's program will be in three parts. The morning session will be devoted to the opening ceremony and keynote address as per the program circulated to you. The second part of it will consist of three consecutive panel discussions on specific themes such as arbitration on regional and international level and on the human rights. They will be chaired by Honorable Minister Sinatambu, Honorable Yerigatu, and Mr. Mulan, respectively. The last and most important part will be the one that is protocolar segment, which is the ceremony for the signature of the convention. Without any further delay, may I now call upon His Excellency Ambassador Chung Hee Han, Chairperson of Ministerial, to make the opening address. Please.
Monsieur le ministre des Affaires étrangères, de l'intégration régionale et du commerce extérieur, Monsieur Etienne Sinatambu, Monsieur le ministre des services financiers et de bonne gouvernance et des réformes institutionnelles, Monsieur Sudashan Badai, Monsieur le ministre de la Justice, Monsieur Khadi Yerigatu, Madame la conseillère parlementaire, Madame Aruna Narai, Messieurs et Mesdames les ambassadeurs, Monsieur le secrétaire général adjoint aux affaires juridiques et conseiller juridique des Nations Unies, Monsieur Soares, mes collègues membres du bureau de commission des Nations Unies pour le droit commercial international, Madame Malawati, Monsieur Moulin, Monsieur Sikilik, éminents orateurs et invités, Mesdames et Messieurs, c'est un véritable honneur et un grand plaisir d'être le premier intervenant de cet événement très important en tant que le président de la Commission des Nations Unies pour le droit et le commerce international. Donc, nous nous souviendrons sans aucun doute dans les années à venir comme ayant marqué le domaine de l'arbitrage d'investissement. Permettez-moi tout d'abord d'étendre mes remerciements les plus chaleureux au gouvernement de Maurice pour l'organisation de cette cérémonie de signature et pour l'hospitalité que nous avons tous reçue à notre arrivée ici à Port-Louis. Je tiens à féliciter l'Organisation des Nations Unies pour l'adoption de la Convention sur la transparence dans l'arbitrage entre investisseurs et États, fondée sur des traités en décembre dernier, convention visant à réformer le domaine de l'arbitrage d'investissement et qui est très novatrice dans son approche. Ladies and gentlemen, we are gathered here today for the signing ceremony of the Mauritius Convention. I know well that the speakers in following panels will dwell more into the substance of the convention, so I dare not reveal the details of that text. But instead, let me share with you the aspect that fascinated me the most. This year marks my 30 years as a foreign diplomat for Korea, and during that period, I have been confronted with numerous situations where policy decisions had to be made. During such a decision-making process, one of the most frustrating moments is when the legal advice informed you that the policy cannot be implemented, not because it is in violation of the law or contrary to the obligations set out in treaties, but because there is no legal mechanism to implement such policy, or it is simply too much of a hassle to design such a mechanism. It gets more frustrating when the legal office does not provide you with a sensible solution to address the problem. The Transparency Convention, however, tells you a different story, a more positive one. In 2013, UNCITRAL adopted the rules on transparency in treaty-based investor-state arbitration, which provide for transparency in investor-state arbitration, reflecting the increased public interest in such dispute. Nevertheless, the rules have their limitation. They would apply only to investment treaties concluded on or after 1st April 2014. Having decided that the level of transparency should be provided for all investment arbitration, the obvious question that followed was, how can the provisions on transparency apply to investment treaties concluded before April 2014? A poor legal advisor would have told us that it was simply not possible because states would have to amend each and every agreement they had entered into in the past to achieve this. UNCITRAL, the core legal body of the United Nations in private international trade law, proved otherwise and found a sensible solution using the often used cliché by thinking outside the box. Confronted with about 3,000 existing bilateral treaties, the Commission was able to prepare a convention which would provide an efficient and flexible mechanism for states that wish to make the rules on transparency applicable to their existing treaties. Till last year, the state had no means to achieve this. From today on, they have the Mauritius Convention, a powerful instrument to enhance transparency in investor-state dispute settlement. I still recall the pleasant moment last year that during my chairmanship, this convention was adopted at the Commission of the UNCITRAL as well as at the General Assembly of the United Nations. And this is why I would also like to commend those who were closely involved in the preparation of this innovative text, mostly the member state and observer state that participated in the deliberation at the working group as well as the Commission sessions. Wide range of intergovernmental as well as non-governmental organizations also took part in the discussion, making it possible to reflect various perspectives. And my special thanks to go to Mr. Salim Mulan from Mauritius, for his marvelous services as the chairperson of the working group that prepared the draft convention. Mr. Bruno Soria, the secretary of UNCITRAL, who unfortunately is not here with us today, and also Mr. Corinne Montineri, the secretary of working group 2, and other staff of the UNCITRAL secretariat for their dedication to this work. I'm quite confident that the route taken in the preparation of the Transparency Convention could provide much guidance for future projects of UNCITRAL, and I look forward to UNCITRAL taking a more significant role in the field of investment arbitration, particularly as the guardian of the Transparency Registry. En ma qualité de président de la Commission des Nations Unies pour le droit commercial international, Permettez-moi maintenant de vous dire quelques mots de l'importance du rôle de la Commission en ce qui concerne l'agenda de développement post-2015 de l'Organisation des Nations Unies. L'un des objectifs primordiaux de ce programme de développement est la promotion d'une croissance économique durable et solidaire. Bien que le rôle central du commerce et de l'investissement comme facteur clé pour lutter contre la pauvreté et promouvoir le développement durable est systématiquement mis en lumière. L'accent est insuffisamment mis sur le cadre législatif qui accompagne le commerce et l'investissement. Sans cadre légal pour les activités commerciales, les États ne seraient pas en mesure de relever le défi qui pose le développement. Le pays en développement ne parviendra pas à stimuler leur économie ni à augmenter le revenu par habitant de leurs citoyens. Ladies and gentlemen, this is why I would like to highlight the relevance of UNCTAD as its pursuance of the mandate to harmonize and modernize international trade law contributes constructively to the sustainable development goals. By assisting states to establish a fair, stable, and predictable legal framework for commercial transactions, UNCTAD provides states with the necessary platform to achieve, among others, economic diversification, financial inclusion, and resilience to economic crisis. UNCTAD's recent work on micro, small, and medium-sized enterprises is particularly noteworthy as MSMEs, which accounts for the majority of developing economies, have limited experience on cross-border trade and access to legal advice. Readily available UNCTAD standards can facilitate their commercial activities, especially cross-border, while reducing transaction costs and commercial risk. The world has become so globalized that no country or business stands on its own. The dimension and implication of international trade is greater in this unprecedentedly interconnected world. Non-existence of or an outdated commercial law framework is a major impediment to integration into global economy, to formalization of informal sectors, and to innovation. In turn, it makes it difficult for states to efficiently mobilize their resources for sustainable development, whether they be from tax revenues, private investment, or development assistance. Overall, adoption by states of international legal standards developed by UNCTAD enhances in the long run the stability of national legislation and builds confidence of the private sector, including foreign investors, in ease of doing business in their state. You may wish to note that the General Assembly of the United Nations reaffirmed that the progressive modernization and harmonization of trade law would contribute significantly to universal economic cooperation among all states on the basis of equality and respect for the rule of law, to the elimination of discrimination in international trade, and thereby to peace, stability, and the well-being of all people. My term as the chair of the UNCTAD will end in approximately 4 months from now on, when the next commission session begins. Nonetheless, I will continue to promote UNCTAD in the post-2015 agenda and would ask for you to do the same, not only within the context of the United Nations, but in your everyday life. I ask you to do so because I firmly believe that UNCTAD and its text could provide a better legal environment for even the one-man company that your friend or neighbor operates. My goal is to reflect this idea in the post-2015 development agenda so that it can be shared view of the United Nations. I really need your support to make this happen. Mesdames et messieurs, en tout dernier lieu, pour revenir à la question qui nous réunit aujourd'hui, la question de la transparence dans l'arbitrage entre l'investisseur et l'État, cette question n'existe pas dans une vie économique. Son importance provient de l'importance de l'investissement comme un outil pour le développement durable, en particulier pour les pays en développement. Il est également certain que les arbitrages entre investisseurs et États sont actuellement l'objet de beaucoup d'attention de la part du public dans de nombreux pays. Dans ce contexte, je voudrais conclure d'abord à le remercier et féliciter les premiers 8 pays qui vont signer la convention aujourd'hui et en invitant instamment les États qui ne sont pas ici avec nous aujourd'hui à envisager de signer et de devenir partie à la convention de Maurice le plus tôt possible. Enfin, je vous demande de continuer à apporter votre soutien à la Commission des Nations Unies pour le droit commercial international dans ses efforts pour la promotion du commerce international et de l'investissement. Merci beaucoup pour votre attention.
Thank you, Ambassador. I just want to remind you that translation facilities are available for those who want to avail. May I now request that the Secretary General, Mr. Miguel de Suarez, to deliver his statement.
Ambassador Han, thank you for that introduction and my sincere appreciation to you for your statement. It was under your able stewardship that UNCITRAL was able to finally lower the anchor after concluding its long journey of transparency in investment arbitration. Honorable Ministers, Attorney General, Parliamentary Council of Mauritius, Excellencies, Bureau members of UNCITRAL, distinguished speakers and guests. Let me also express how honored I am to be addressing you here in a country that has truly embraced international arbitration as an effective method of resolving commercial and investment disputes. I am particularly pleased because this is my first visit to Mauritius since taking up my duties as the Legal Counsel of the United Nations. As you well know, UNCITRAL is a commission established by the General Assembly with a mandate to harmonize and modernize international trade law. The secretariat functions of the commission are bestowed upon the International Trade Law Division, one of the 6 divisions in my office, the United Nations Office of Legal Affairs. As such, I would like to take this opportunity to reflect briefly on UNCITRAL's overall role and particularly with regard to its recent achievements in the preparation of legal standards on transparency in investment arbitration, which bring us together today. Now, UNCITRAL has made significant contribution to developing and promoting international standards in the field of arbitration. The near universal accession to the New York Convention highlights the need for arbitral awards to be recognized and enforced abroad. The success of the New York Convention and its increased use are a tribute to the role of arbitration as a peaceful means of settling international disputes, as are the numerous enactments of arbitration legislation based on the UNCITRAL model law of international commercial arbitration and the extensive use of the UNCITRAL arbitration rules. UNCITRAL continues to work diligently in the field of dispute resolution, and I have been informed that the working group on arbitration and conciliation is currently revising the UNCITRAL notes on organizing arbitral proceedings with very interesting topics on the table for its future work: enforcement of settlement agreements and concurrent proceedings in investment arbitration. UNCITRAL's work on transparency sprouted from the experience gained by UNCITRAL in the field of international arbitration, and the significance of ensuring transparency in investment arbitration stems from the role of investment as a tool for sustainable development. Put together, these elements provided the basis for UNCITRAL to promote transparency and inclusiveness, both expressions of core United Nations values as they relate to human rights, good governance, and the rule of law. In this context, UNCITRAL commenced work on transparency in investment arbitration in October 2010, and after 3 years, in 2013, the transparency rules were adopted by consensus. The adoption of the text constitutes an important achievement in light of the subject matter addressed by the rules, the right of access to information. The transparency rules represent a fundamental change from the status quo of investment arbitrations, often conducted behind closed doors and hidden from the public view, even when the issues being raised gather much attention from the public and the media. Without going into much detail, the rules, when they apply, provide a procedural regime that gives the public, as a matter of course, broad access to a wealth of documents in a dispute. The rules also provide for open hearings and the qualified right for third parties to make submissions. They include robust safeguards for the protection of confidential information. And most importantly, they balance the public interest in receiving information and the interest of disputing parties for a fair and efficient resolution of that dispute. As mentioned by Ambassador Han, because the transparency rules only apply to investment treaties concluded after the 1st April 2014, the Commission began preparing the Convention to give those states that wish to make the transparency rules applicable to their existing investment treaties an efficient mechanism to do so. That result of the Commission's hard work was eventually approved by the General Assembly of the United Nations, and it has brought us all here. All in all, I firmly believe that the conclusion of the Mauritius Convention is a momentous occasion in the field of investment arbitration. By becoming parties to the Mauritius Convention, states agreed to apply the transparency rules to arbitration arising under their existing investment treaties, either unilaterally or on a bilateral basis. And at this point, I will also emphasize the flexibility provided to states under the Convention, as states are allowed to exclude from the scope of the Convention certain investment treaties, certain sets of arbitration rules, or unilateral applications. With the transparency rules and the Convention now firmly in place, the question that follows is whether relevant information would be available to the public. In fact, the central feature of both the transparency rules and the Convention is the repository function stipulated in Article 8 of the rules. Now let me underline the importance of the Transparency Registry, which will be a unique place for governments to share information about investment cases in law and for policymakers and government officials to gain first-hand knowledge of how the system functions. Once cases will be brought under the transparency rules, the registry will provide consolidated, transparent and easily accessible global case record database for all investor state arbitrations conducted pursuant to the transparency rules and the transparency convention. This is quite significant because the transparency rules are currently the only existing universal standalone standard in the field. UNCITRAL has become known worldwide for establishing modern legal rules regulating international commerce in a neutral and balanced manner and assisting states and other relevant stakeholders with the understanding, enactment, implementation, and interpretation of those standards. As also mentioned by Ambassador Han, 2015 marks another important turning point in the work of the United Nations as a new post-2015 development framework is due to be agreed in September. We can look with great pride at the work of UNCITRAL and its contribution to development over the past decades, and I firmly believe that there is more that UNCITRAL can contribute to the post-2015 Sustainable Development Agenda. In fact, its work lies at the heart of the mission of the United Nations as reflected in the preamble of the Charter, which calls upon the United Nations to employ international machinery for the promotion of the economic and social advancement of all peoples. Now let me conclude by providing you with some information about a new development at the United Nations. In August 2014, the Secretary General established an independent expert advisory group to make concrete recommendations on bringing about a data revolution in sustainable development, which has now published its report. If I may cite the expert group's words, and I quote, "Data are the lifeblood of decision-making and the raw material for accountability. Without high-quality data providing the right information on the right thing at the right time, designing, monitoring, and evaluating effective policies becomes almost impossible." End of quote. The Mauritius Convention and the idea of transparency it spreads could also be understood in this general trend of data revolution. By making it possible for information about investment arbitration to flow to the public, it creates accountability of the process as well as the parties involved. UNCITRAL standards of transparency, combined all of them, the transparency rules, the Mauritius Convention, and the Transparency Registry, are the first successful multilateral attempt to reform investment arbitration, an area of much public and media attention at the moment. Where human rights and other public interests are concerned, transparency should be a governing principle. The rules on transparency, which came into force on the 1st April 2014, and the Mauritius Convention, which opens for signature today, comprise a critical step in achieving that aim. I thank you for your kind attention.
Thank you, Excellency Mr. Suarez. Now I have the honor to request Honorable Sudarshan Bhatia, Minister of Financial Services, Good Governance and Institutional Reforms, to address. Thank you.
Honorable Secretary for Legal Affairs, Honorable Chairman of UNCITRAL, Honorable Ministers, Excellencies, members of the press, ladies and gentlemen. It is a pleasure for me, on behalf of the government of Mauritius, to extend a warm welcome to all of you to Mauritius and to this opening ceremony for the signature of the United Nations Convention on Transparency in Treaty Arbitration. It is with great honor that I welcome in particular our special guest, the Under-Secretary General for Legal Affairs of the United Nations, Mr. Sir Suarez, and the Chairman of the United Nations Commission on International Trade Law, Ambassador Chu Gi-han. Today's event is a momentous occasion, not only from an international law perspective, but also as a further step for Mauritius in our endeavors to become an integral part of a global system of peaceful adjudication of disputes. As you will be aware, Mauritius has engaged in a systematic effort to establish itself as a safe seat for international arbitration and as a regional center of excellence for training and capacity building in this field. I am pleased to announce that not later than yesterday, my ministry has agreed to provide all the support for the infrastructural setup of the Mauritius International Arbitration Center, which will be operational as from January 2016. This process has been lagging behind for the past 6 years or so on account of administrative burden, and my ministry, in collaboration with the Prime Minister's office, have taken the initiative to facilitate this process in the physical setup of an international arbitration center in Mauritius. This goes in line with government's vision to bring more substance to the Mauritian International Financial Center and springboard the country on the international front as an international center of excellence for arbitration. Mauritius has become the country of choice in Africa to do business. The World Bank and other organizations have consistently ranked Mauritius first among African economies in terms of overall ease of doing business, governance, and transparency. Mauritius is wholly integrated in the African region as a leading member of the African Union, of the SADC, the Southern African Development Community, and of the COMESA Common Market for Eastern and Southern Africa. But like Singapore in Southeast Asia or Switzerland in Europe, it is also uniquely open to the rest of the world. Mauritius' experience in the financial services industry for which I am responsible demonstrate the confidence which foreign investors have in our jurisdiction and the ease of doing business in our country. Mauritius is home to a great number of global business companies. It is the largest foreign direct investor in India, a position recently recovered from Singapore. In fact, it is a matter of pride that the Right Honourable Prime Minister of India, Shri Narendra Modi, has unequivocally stated that Mauritius and India will work together to address treaty abuse, and India will do nothing to harm the interests of the Mauritius Financial Center. This is a loud and clear message of trust and confidence to foreign investors in our financial center. Mauritius is fast becoming the hub for all transactions involving Africa, both for its traditional client base, large and medium-sized US and European corporations, and for a new wave of investors coming, in particular from India and also from China. Mauritius has an established and stable democratic system of government based on the Westminster model, with a deeply rooted respect for the rule of law and a unique blend of civil and common law heritage. Crucially, Mauritius has the added advantage of being perceived as a neutral country from both a developed world and a developing world perspective. A decision was accordingly taken to start a systematic effort to use those assets to turn Mauritius into a safe and efficient place to arbitrate. We enacted a state-of-the-art new International Arbitration Act based on the UNCITRAL model law and amended and improved that act and related rules of court. We signed a host country agreement with the Permanent Court of Arbitration at The Hague, which has for the first time in its history appointed a permanent representative outside The Hague. Mauritius held a launch conference for its new arbitration platform in December 2010 under the aegis inter alia of UNCITRAL of the World Bank International Center for Settlement of Investment Disputes, ICSID, and of the VCA. This attracted some 400 delegates from Africa and beyond, and has become a biennial event. MIA 2014 was held in December 2014 and was similarly successful attracting numerous African judges, ministers, and leading lawyers. Numerous training activities for Mauritian and African judges and practitioners are now also being held on a regular basis. A joint venture agreement with the LCIA was signed in July 2011, creating a state-of-the-art and independent arbitration center, LCIA MIAC, which has already handled its first cases. Mauritius bid and won the right to host the 23rd Congress of the International Council for Commercial Arbitration from 8th to 11th May 2016, and we're looking forward to that. I would also venture to say that this has all the hallmarks of the beginning of a success story. But for whom? There is one obvious answer and two more subtle ones. Obviously, there are tangible collateral economic benefits for a country that hosts arbitration hearings, the financial services sector, and the legal services sector, hotels and ancillary service providers stand to benefit. Moreover, to the extent that the legal seat of arbitral proceedings is in Mauritius, Mauritian lawyers may be engaged in proceedings before the Mauritian courts that relate to arbitration, although our International Arbitration Act is designed to ensure that these are kept to a minimum, and that our courts will at all times support rather than disrupt arbitral proceedings. But there is a deeper reason why Mauritius is building up capacity in international dispute settlement. Promoting arbitration means promoting the rule of law. By establishing itself as a preferred arbitration venue, Mauritius stands for legal certainty and also for good governance. Whilst Mauritius proudly markets its beaches, textiles, IT expertise, and financial services, we feel that we have an even more precious asset to offer: a predictable legal framework within a stable political system. The third reason for promoting arbitration in Mauritius relates to inclusiveness. Arbitration has a long history, but it is not only European or Western. Yet, it is hard to deny that contemporary arbitral practice is still largely defined in the developed world. Several institutions have identified that problem, and UNCITRAL in particular is playing a constructive role in overcoming the perceived bias in the geography of international arbitration. But if one looks at the statistics that ICSID issues about its registered investment cases, it turns out that 2% of arbitrators are from sub-Saharan Africa and 4% from North Africa and the Middle East. And this despite 27% of all cases originating in Africa or the Middle East. To my knowledge, no official figures exist that would demonstrate the frequency of investor-state hearings held in Africa, but I would venture to suggest that the figure is close to zero. And this, to make the point again, despite more than a fourth of the respondent states being African or Middle Eastern. I do not state these facts to stir controversy. The point is that Africa and other parts of the developing world are embracing arbitration today, and rightly so. In doing so, however, we must become owners of the system, not only mere users. We must learn the professional codes of the discipline to appropriate it and shape it in our own ways. Mauritius is committed to making its contribution to capacity building so that international arbitration can progressively become part of the legal and cultural DNA in our region. Before concluding, I would like to reiterate government's commitment to the international community in the light of the international arbitration project. Government is acutely aware that its role and will only ever be to ensure the existence of the most favorable conditions for international arbitration in Mauritius, with absolutely no interference in this field beyond that assistance. By way of example, the joint venture agreement between government and the LCIA creates the material and financial conditions for the center to exist, but leaves it to the LCIA to run and administer the center with absolutely no interference from government. Similarly, Our host country agreement provides the PCA with the necessary funding to maintain its presence in Mauritius, but leaves the PCA with complete independence and freedom in its operations, including, of course, when discharging its quasi-statutory functions under our International Arbitration Act. This has always been and will continue to be our guiding principle on this project. Allow me to conclude by congratulating UNCITRAL and also a special thanks to an exceptional person, my friend Salimona, for his hard work, enthusiasm, passion, and sheer dedication to bring this project to fruition. On behalf of the government, thank you, Salim. Ladies and gentlemen, I welcome you all once again to Mauritius and wish you an enjoyable stay. Thank you.
Thank you, Honorable Minister, for your address. We have now the pleasure and honor to request Honorable H.N. Sinatam, Minister of Foreign Affairs, Regional Integration and International Trade, to deliver the keynote address.
My good friend and colleague, Sudarshan Badhan, Minister of Financial Services, Good Governance and Institutional Reform. My other good friend and colleague, the Honorable Attorney General of the Republic of Mauritius, Ravi Yerigadu, Your Excellency, Mr. Suarez, the Under Secretary General for Legal Affairs and Legal Counsel of the United Nations, Your Excellency, Ambassador Chong Hee Han, the Chair of the United Nations Commission on International Trade Law, Excellencies, members of the Diplomatic Corps, distinguished delegates, distinguished guests, ladies and gentlemen, good morning and welcome to the signature ceremony of today's event, which is the signature ceremony of the United Nations Convention on Transparency and Treaty-Based Investor-State Arbitration. When Ambassador Dillon, who is head of directorate of my ministry, said that I was going to deliver the keynote address, I must say that it is quite difficult to be the last of 4 speakers in an opening ceremony, because very often what you would like to say in your keynote address has to a large extent been stated by the first 3 speakers. And to a large extent, this has been the case this morning. One of the things which, however, I can certainly reiterate is the fact that it is with great honor that Mauritius is today welcoming all of you, including our special guests, to this signature ceremony. I think it can also be said, without any doubt, that your presence here underscores the international significance of today's signature ceremony of this Convention on Transparency in Treaty-Based Investor-State Arbitration. Now, I was delighted yesterday to learn a few months ago that it would bear the name of the Mauritius Convention. Maybe it is indeed the case that signing a treaty of that nature is historical. Maybe it could also indeed be the case that the signature of such a convention in Mauritius for any Mauritian, for any Mauritian official, for any Mauritian minister, and for any Mauritian government, that we will all go, but the Mauritius Convention will stay. And I think I can tell you that I, for one, am very proud that this has been achieved with the help of very many people. One individual has already been thanked, and our gratitude has been expressed to him. But I will not say other names in case I miss a few of them. But indeed, to all those who have worked towards this particular signature ceremony, towards the consensual adoption of the United Nations General Assembly resolution, which adopted the convention. Yes, thank you very much for all the efforts. Mauritius is indeed very grateful to you. Now, I think no one will disagree that in the past quarter of a century, Mauritius has done its level best to develop into a hub for international business transactions and trade. In fact, I'm very happy to see among the delegates here Director of International Trade Division of my ministry, the Director of Regional Integration, because it does show how Mauritius has tried to develop into this international economic and trade hub. And indeed, when Mauritius embarked into attempting also to become an arbitration hub, it was not in a manner to compete with the rest of the world, but it was in a manner to partner with other existing hubs. To that extent, my good friend, Honorable Bada, has explained, has described just a few minutes ago, how we can also be proud that the Permanent Court of Arbitration in The Hague has its only other representative in the world in Mauritius. And we must also bear in mind what he has said about arbitrators from sub-Saharan Africa making up about 2% of the total number of arbitrators around the world. But the arbitration cases in that part of the world, sub-Saharan Africa and Middle East, although 2% there are being arbitrated, but 27% of arbitration matters, of arbitral matters, being from that region. And this is where I am convinced that what we are doing today and what we have done in the last 25 years are complementary. Let me just perhaps highlight two of the decisions taken in the last 3 months by the Mauritian government from international trade point of view. The first one was the decision by the government of Mauritius to actually send its letter of acceptance regarding the World Trade Organization Trade Facilitation Agreement to the Secretariat of the World Trade Organization in February. What had happened is that this agreement was signed in December 2013 at the 9th Ministerial Conference of the World Trade Organization Ministers. But somehow, this agreement actually opens up business, and only for the SADC COMESA region, we are speaking of exports worth $400 billion US. Now, because we are speaking of a multilateral agreement, because we are speaking of treaty-based eventual state-investor-state arbitration, are we not going in the right direction when we now ratify those agreements? The other decision taken by the Mauritian government has been the decision to actually start negotiations in the trade and services agreement. As you may all be aware, it is now nearly 2 decades that the World Trade Organization has not been able to secure any agreement as regards trade and services. And what happened is that in March 2013, 23 member states of the World Trade Organization, constituting nearly 2/3 of the world economy, decided to adopt a plurilateral approach and started the negotiations on trade and services agreement. And I am glad that the government of Mauritius has decided to enter into those negotiations as the next member. Now, what must be observed here is that trade and services of those member organizations make up not only 2/3 of the world's economy, but the trade and services of those countries, in terms of exports, amount to $4.4 trillion, and their imports amount to $4.2 trillion US. And I think we're all aware that wherever there is money, there is likely to be dispute. So what a good idea that this particular signature, this particular convention, in my mind, comes in very handy, because it will allow more transparency. I think what the world has seen in the last few years is the need for more transparency. Not only in what we call treaty-based investor-state arbitration, but in every single sphere. So what is happening today is indeed most striking. What I would say more is that I personally believe that the Mauritius Convention on Transparency fits naturally within the vision for Mauritius. Transparency, indeed, is an enabling condition for both corporate accountability and for political checks and balances. So, to me, not only does investment arbitration usually raise questions of deep public concern, but I think that they also raise big questions of political integrity. So here is one of the ways of making sure that we tackle both sides of the problem. Indeed, it is also quite fitting here that I should commend the work done by the United Nations Commission on International Trade Law itself. I believe that the Mauritius Convention adds ambassador to the prestige of UNCITRAL and to its impressive and field record of achievements, as reflected in various other important texts. In seeking to be part of the supranational decisions that affect our future, in Mauritius, we are fully aware of our limits. But we are also convinced that in a new, global and interdependent environment, Mauritius can offer as much as others. Our collaborative work with UNCITRAL in the lead-up to the drafting and adoption of the Mauritius Convention and its signature not only underlies our conviction in what has been done. But we want to assure everyone here and the United Nations in general that we would like to continue to be partners in other endeavors which happen to come up. With these remarks, ladies and gentlemen, I wish all of you an engaging conference day. I hope that you will join us after the conference and the signature ceremony for a small reception. And if you come to Mauritius, you're not allowed only to stay in air-conditioned halls. You have to come to receptions and look at our beaches and our nice lagoonal blue water. I am delighted now, after having said a few words, to declare the event for the signing ceremony of the Mauritius Convention on Transparency officially open. Thank you, ladies and gentlemen.
Thank you, Honorable Minister, for your recognition. I have just one thing to remind Member States that the list of speakers for the signature ceremony will be closed at 15 hours. So kindly register with the registration desk. So, Excellencies, ladies and gentlemen, we have come to the end of the first part of our program. The opening ceremony is concluded. We'll now invite all of you for a break of half an hour. So we'll be back to this room again at 11:30. Thank you. Honorable Ministers, Excellencies, ladies and gentlemen, thank you very much. We will shortly start with our first panel discussion chaired by Honorable Ravi Gatto, Attorney General of the Republic of Mauritius, on the topic Investor-State Arbitration and Human Rights. Honorable Gatto.
Thank you. Ladies and gentlemen, colleague ministers, distinguished guests, I'm honoured this morning to chair this panel on investor-state arbitration and human rights. There is no doubt a human rights dimension attached to investor-state arbitration. It is here apposite to cite a commentary to Principle 9 of a UN Guiding Principle on Business and Human Rights, and I quote, "Economic agreements concluded by states, either with other states or with business enterprises, such as bilateral investment treaties, free trade agreements, or contract for investment projects, create economic opportunities for state. But they can also affect the domestic policy space of governments. For example, the terms of international investment agreements may constrain states from fully implementing new human rights legislation or put them at risk of binding international arbitration if they do so. Therefore, states should ensure that they retain adequate policy and regulatory ability to protect human rights under the terms of such agreements when providing necessary investor protection." End of quote. Now, to address us on this topical issue this morning, we have an eminent panel consisting of Mr. Michael Addo, Mrs. Gabrielle Kaufman-Currer, and Mr. James Castillo. Mr. Michael Addo is an academic expert in international human rights law with a particular focus on its implications for international business policy. He is currently senior lecturer at the University of Exeter, UK, where he researches and teaches international law, human rights, and human rights and business policy at both undergraduate and postgraduate levels. In this capacity, Mr. Addo has successfully supervised doctoral research in diverse fields of international human rights law, including in the field of business and human rights. Mr. Ado, has authored and edited several books and scholarly publications, including one of the earliest collection of essays on human rights standards and the responsibility of transnational corporations. Mr. Ado is a lawyer by training and an advocate at the Ghana Bar. Mrs. Gabrielle Coffin-Kohler is a founding partner of Levy Coffin-Kohler. She's also a professor and director of the Department of Private International Law, School of Law, Geneva University. She has acted as arbitrator and counsel in over 150 commercial and investment cases, as well as over 50 sports arbitrations, and is listed as arbitrator of a number of institutions, including ICC, ICSID and WIPO. She has been the chair of the Court of Arbitration for Sports, CAS, Olympic Division from 1996 to 2000, and Ordinary Division from 1993 to 2001. Mrs. Gabrielle Coffin-Kohler has published extensively in the areas of her specialization, which are private, international law, especially international contracts, international civil procedure, international commercial arbitration, resolution of sports disputes, and online dispute resolution. Last but not least, Mr. James Costello, partner in King & Spalding's Paris office, is a member of the firm's International Arbitration Group. In more than 27 years as a practicing lawyer, Mr. Costello has advised and represented clients in a wide range of legal disputes, particularly international arbitrations, both institutional and ad hoc, commercial, as well as investor state. In 2007, he was named to a 5-year term in the London Court of International Arbitration, where he served the drafting committee for the revised 2014 LCIA arbitration rules, and he now serves as president of the LCIA's European Users Council. Since 2001, Mr. Costello has also served in the US delegation to the Arbitration Working Group and at the United Nations Commission on International Trade Law, UNCITRAL. Amongst numerous publications, Mr. Costello has written the chapters on the UNCITRAL arbitration rules and the Practitioner's Handbook on International Commercial Arbitration and the World Arbitration Report. Ladies and gentlemen, I have now the immense pleasure of inviting Mr. Michael Ado for his presentation. Michael.
Honourable Chair and Chair of our panel, Honourable Minister for Financial Services, Good Governance and International Reform of the Republic of Mauritius, Honourable Minister for Foreign Affairs, Regional Integration, International Trade of the Republic of Mauritius, Honourable Chair of UNCITRAL and Honourable Under-Secretary General for Legal Affairs of the United Nations, Excellencies, distinguished representatives of states, ladies and gentlemen. First of all, I'd like to thank our chair for a very kind introduction, and I also particularly want to thank him for opening his remarks with Guiding Principle 9 on the United Nations Guiding Principles on Business and Human Rights, which is particularly relevant to my intervention. Now, we are gathered here today to witness the signing of an important treaty that has a very genuine potential to transform the landscape of investor-state arbitration. I therefore wish to join and associate myself with the speakers before me in congratulating and commending the United Nations Commission on International Trade Law, UNCITRAL, and its working group on arbitration and conciliation for this pioneering contribution to the development of international law, and also to express my very personal gratitude to the government of Mauritius for the very kind invitation extended to me to participate in this process. Now, the signing of the treaty is by its very nature a state-centered process as part of very traditional ways of developing international law. However, it is important to acknowledge that the subject of today's ceremony transcends pure governmental action. In fact, its implications may be felt in the private sphere by private actors whose direct role and contribution in this exercise may not always be publicly acknowledged. Therefore, Mr. Chairman, Excellencies, ladies and gentlemen, on this landmark occasion of the signing of the Mauritius Convention on Transparency in Investment, please allow me to say a few words about the United Nations Guiding Principles on Human Rights and Transnational Corporations and its working group with a mandate from the United Nations Human Rights Council to promote the effective dissemination and implementation of the Guiding Principles. The working group is a body of 5 independent experts that I have the honor of chairing, and the Guiding Principles were unanimously endorsed by the Human Rights Council in 2011 as the first authoritative global framework to define the respective duties of governments and the responsibilities of business in addressing adverse human rights impacts. The Guiding Principles are structured under 3 pillars, including the state's duty to protect, but also the corporate responsibility to respect human rights, as well as access to effective remedies. Mr. Chair, distinguished delegates, I make these introductory remarks for 2 very good reasons. Firstly, to affirm the shared vision of the working group, or our working group, with those of the convention that we are here gathered to sign. At the core of that vision is the importance of the rule of law, due process, human rights, and procedural fairness. On our working group, we see that the Mauritius Convention complements the holistic and integrated approach proposed in the Protect, Respect, and Remedy framework on which our guiding principles are based. It is for this reason that at our session in May 2014, our working group was very pleased to meet with the representative of UNCITRAL Secretariat to share information and to discuss possible areas of collaboration. At that meeting, the working group was briefed on UNCITRAL's rules on transparency in treaty-based investor-state arbitration and the progress with the development of the treaty, the signing of which we witnessed today. Secondly, I wish for my introductory remarks to hint at the importance of an emerging paradigm of international lawmaking. And this is the emerging hypothesis that recognizes the role, the contribution, and the responsibility of private actors, especially business enterprises. And the United Nations Guiding Principles seeks to respond to the challenges posed by this idea of looking beyond governmental duties and obligations for an effective realization of international law ideals. Ladies and gentlemen, arbitration as a method of settling disputes is a valid and recognized process for effective remedy for the violations of human rights of investment, and that is true. But I also argue that arbitration should be good enough for the protection of rights of other actors. One of the key characteristics of an effective remedy is that it should command legitimacy in terms of enabling the trust of its users and being accountable for the fair conduct of its grievance process. And to do this, it has to be accessible, it has to be predictable in terms of providing a clear and known procedure with indicative timeframes for each stage, and above all, it has to be transparent in terms of keeping parties to the grievance informed about its progress and providing sufficient information about the mechanism of performance to build confidence in its effectiveness to meet public interests. The Transparency Convention, I'm delighted to say, brings added value to treaty-based investor-state arbitration by contributing to the legitimacy, to the trust, and therefore overall effectiveness of investor-state arbitration process. The Transparency Convention, in my view, affirms important principles of human rights, including equality of arms between litigants, aspects of freedom of expression, including the right to receive and impart information, and these are extremely helpful, but the full value of human rights in trade and investment will only be achieved when national legal systems systematically embedded human rights standards into national law. And the key to effective embedding of human rights in trade and investment policy at the national level is, in my opinion, for states and their representatives to recognize and appreciate the links and implications of their very different international obligations. Often the links between states' international human rights obligations on the one hand and those of economic agreements such as bilateral investment treaties of free trade agreements, on the other hand, are not so easily appreciated. And this is where I'm delighted to refer to the quotation made by our chair, because I too would like to quote the United Nations Guiding Principle, Principle 9, which recognizes this disengagement between human rights and economic policy, and therefore proposes that states should maintain adequate domestic policy space to meet their human rights obligations when pursuing business-related policy objectives with other states or business enterprises, such as investment treaties and investment contracts. I wish to make three other broad propositions for ensuring the place of human rights in trade and investment policy at the national level. And the first is to reiterate the call that the United Nations Working Group on Business and Human Rights has made to all states to adopt national action plans on business and human rights. And the second is to invite states to consider expanding the scope of human rights guarantees in investment treaties and investment contracts. And thirdly, to also invite states to also consider sharing responsibility with other actors, including non-state actors, in the development of human rights policy. And first of all, national action plans. In the implementation of the United Nations Guiding Principles on Business and Human Rights, our working group has called on all governments to develop national action plans on business and human rights as a means to facilitate a stock-taking of current gaps in laws and current strengths in regulations, and so from there to formulate clear roadmaps to address gaps in their national legal frameworks. The fundamental purpose of a national action plan is to ensure policy coherence both vertically and horizontally, as well as to prevent and strengthen policy practice for the protection against adverse human rights impacts by business enterprises through an inclusive process of identifying needs and gaps and the practical and actionable policy measures and goals. The National Action Plan quite definitely should consider the role of investment law at the national level, and therefore human rights and investment law. I'm delighted to say that several states, including a good many gathered here, have already developed or are in the process of developing national action plans on business and human rights. And our working group encourages states and business enterprises and civil society groups to work together and share experiences and good practice in developing national action plans. We are pleased that the number of national action plans developed by states is on the increase. However, there is still room for improvement, particularly on our dear African continent. We are aware that national human rights institutions and civil society actors are increasingly pushing for the development of national action plans. And we encourage donors and international regional organizations to support governments in developing national action plans to implement the guiding principles, and also to support civil society actions for the cause of national action plans. So as to help in the development of national action plans, the working group has developed guidance documents to assist in the preparation of national action plans. And this guidance document is available on our website and will be refreshed periodically. And we would like to seek the support and collaboration of Institutrol to explore opportunities for further collaboration in the development of national action plans. As far as collaboration is concerned, we are very pleased that at its 47th session, the Institutrol Commission agreed with our proposal that its secretariat should monitor the developments in the area of business and human rights and propose ways of collaboration, and we look forward to this further collaboration because we consider this collaboration to be very important. We very much hope that and anticipate that we will continue to work with the Institutional Commission in this regard. My second proposition for embedding human rights investment, national law investment in trade, is to invite states to revisit and rethink the place of human rights in investment agreements, where the traditional focus and emphasis has been on securing on the rights of investors. This is important, this is fair, and this is necessary. However, experience seems to suggest that this is not enough, and there is therefore a need to revisit or widen the scope of human rights in such treaties. The United Nations Conference on Trade and Development has addressed this subject by proposing an investment policy framework for sustainable development, in which it seeks to emphasize the relationship between foreign investment and sustainable development by advocating a balanced approach between the pursuit of economic growth objectives by means of investment, liberalization, and promotion on the one hand, and the need to protect people, their human rights, and their very environment on the other hand. The investment policy framework for sustainable development is particularly helpful in its definition of core principles of investment policy making. It also provides guidelines for national investment policy, but above all, it provides guidance for policy makers on how to engage in international investment policy reform, taking account of human rights. And human rights are the core, and the essence of the investment policy framework is for states to consider not only rights of investors, but also to restate the responsibilities of investors, particularly private actors, in such treaties. Finally, I wish to also invite states to begin to consider sharing human rights responsibility with other actors. Globalization has taught us, if nothing at all, very many lessons, including the growing importance and influence of non-state actors, including business enterprises. This is especially true in the field of trade and investment. We know that the traditional view of human rights as applicable in the public sphere is good enough. We also know from experience that human rights are very relevant in the private sphere. In recognizing the responsibility of such actors and constructing policy to take into account the essential characteristics of this responsibility is crucial for effective governance. It is therefore necessary for us to align business enterprises, who remain some of the most powerful actors and forces in our economic world, with the human rights priorities that we have set in the global community with the United Nations in 1945 and thereafter. In this regard, therefore, scaling up the implementation of the United Nations Guiding Principles should be an urgent priority for all states and business enterprises. We also invite all stakeholders, including victim groups, civil society groups, to consider joining in the implementation of the Guiding Principles. But above everything else, we look for and value the engagement with UNCITRAL in developing effective ways of reaching private actors. Indeed, at the very last Forum on Business and Human Rights, which we organize and convene every year, many panels touched upon issues related to investment and state arbitration, and the United Nations Working Group looks forward to further engagement and collaboration over the coming years. And I particularly would like, in my capacity as chair of the working group, to extend a very warm invitation to all of you to join us in Geneva for the 2015 Annual Forum on Business and Human Rights, which will take place from the 16th to the 18th of November 2015. On this note, I'd like to thank you again for the very kind invitation to address you and to say for your very kind attention. Thank you very much.
Thank you, Michael, for your inspiring presentation. And I have the pleasure to invite Mrs. Gabrielle Kaufman-Kohler for a presentation on transparency, accountability, and access to information as important values in treaty-based investor-state arbitration. Gabrielle.
Mr. Attorney General, thank you very much for the introduction. Honorable ministers, excellencies, ladies and gentlemen. I'm very honored and I'm very happy to be here today. I'm grateful to the government of Mauritius and to UNCITRAL for the invitation, and I'm thrilled to participate in this celebration of the Mauritius Convention on Transparency. The convention marks a turn in the history of investor-state dispute settlement. It signals a shift in paradigm from commercial arbitration, which was a traditional model, to public law dispute resolution involving public interests and international obligations of states. It is a shift towards making investor-state dispute settlement more accountable. And that leads me to my topic of today. The organizers have asked me to speak about, I need to check because there's a number of topics. Transparency, accountability, access to information. In other words, the field is wide and the time is short. So let me go directly to my key finding, which of course I will then address in more detail. The key finding is that all these values that are essential to democratic government, that are essential to the rule of law, are present in investor-state arbitration. Now, some are more visible than others, some may need reinforcement as we go along, but they're all embedded in investor-state arbitration. So I will try and illustrate this by starting with access to information, then briefly speak about transparency, and spend a little bit more time on accountability. And with access to information, I will also look to some other human rights, and that will follow up on what my predecessor speaker addressed. Access to information. It goes without saying that by signing the Mauritius Convention on Transparency, states today and in the weeks and months that will follow will implement the human right of access to information, the human rights by the European Court of Human Rights, by the Inter-American Court, by the general comment of the Human Rights Council on the Covenant of Civil and Political Rights. Actually, access to information is already present in numerous investment treaties that impose on host state governments the obligation to publish laws and regulations that affect foreign investment. In newer treaties, there is also a trend to impose obligations of disclosure on investors. And that is an interesting phenomenon in the sense that it means that transparency here is playing both, is working both ways. What would we say about procedural human rights? For instance, participation, which is part of freedom of expression, is implemented in investor-state arbitration by the possibility for civil society to make submissions on the topic of the investment dispute by way of amicus curiae groups. That is one of the achievements of the Transparency Convention, which, by the way, is not only about transparency, it's also about amicus curiae submissions, it's also about non-disputing states participating in the investment arbitration. So that is for participation. Obviously, it goes without saying, but maybe it should not be forgotten that by entering into treaties providing for investment arbitration, states do implement the right of access to effective justice. So far on procedural human rights. What about substantive human rights? Do investment tribunals apply substantive human rights? Well, the answer is yes and no. No, because it's not their task. Their task is not to make rulings on human rights violations. Their task is to make rulings on investment treaty obligations, and that is what they do. Now, at the same time, one could say yes, in a certain way, they do apply or at least take into account substantive human rights. For instance, when an investment tribunal makes an award of damages for as a result of an unlawful expropriation, it does protect the right to property or the right to possession, which is a human right. So it participates in the implementation of human rights. One could also say yes, in the sense that in their assessment of treaty breaches, in their assessment of the regulatory powers of states, tribunals should take into account, must take into account, I would say, human rights. They do so, for instance, as well for environmental law. I was struck by news last week that the World Health Organization has asked and have been granted permission to submit an amicus curiae brief in the Philip Morris versus Uruguay exit arbitration. No doubt, as part of the submissions of the World Health Organization, there will be considerations of the right to health and other human rights. Substantive human rights could also come into play in investment arbitration from a different angle, that is from as a defense raised by a state against a claim made by an investor. That assume an investor makes a treaty claim against the state, and the state says, no, you are deprived, you investor, from your right to treaty protection because you have engaged in child labor. If there is a rule in national law and there is a requirement in the treaty for the investor to comply with national law, which there is very often, then obviously the investor will be deprived from protection. But the investor could also be deprived in another way, and that leads us directly to the topic of Mr. Ado a moment ago. If the investment treaty incorporates corporate social responsibility principles about human rights and business, that may be as a defense as well for an investor claim. So there are different ways for investment tribunals to take account or apply substantive human rights. I have noted on my paper that the investment arbitration of COMISA has particularly advanced provisions in this respect, and I thought that was worth noting here today. So much on access to information on other human rights and investment arbitration. I will be briefer on transparency. I have already touched, of course, on transparency by speaking of access to information, which is a facet of transparency. One could add here that there are a number of arbitration awards by investment tribunals that have considered that non-transparent conduct by a state may be a breach of an investment treaty. That of course depends on the wording of the treaty. If there is no specific guarantee of transparency in favor of investors in the treaty, then certain tribunals have found that this may be a component of a fair and equitable treatment. My submission is on the basis of the jurisprudence as it lies today that mere non-transparent conduct may not be a violation of fair and equitable treatment, but a finding of non-transparent conduct may reinforce a finding, for instance, of discriminatory conduct or arbitrary conduct and lead to a finding of breach of fair and equitable treatment. Let me go now to my third topic, which is accountability. The word is easily used because it conveys an image of trustworthiness, transparency, again, integrity. At the same time, there is no consensus on the content of the notion of accountability as a value, or if you prefer, as a virtue. And therefore, I do prefer focusing on accountability as a mechanism to achieve other values, democratic aims, and the rule of law. So if we speak of a mechanism, that the mechanism implies that someone reports or is responsible or is accountable to someone else for something. Now, if we transpose this to investment arbitration, the question becomes in investment arbitration, who is responsible for what to who? If I start with who, the states, by the exercise of their sovereign powers, have accepted to be held accountable by investment tribunals for violations of the obligations they have defined in the treaties. That is one thing. Investors could be held accountable as well if the treaty imposes obligations on them, such as corporate social responsibility obligations. The position becomes more difficult when you get to the tribunal. The investment arbitral tribunal, for what is it accountable, for what is it responsible? To answer this question, I think an analogy was the judiciary is helpful because, and I believe also the analogy is justified. The states entrust to investment arbitrators the resolution of investment disputes, as they entrust to judges the resolution of all kinds of other disputes. And so that there is no significant difference between the office of a judge and the office of an investment arbitrator. Judges are accountable to apply the law in a fair and impartial manner. That is certainly transposable to investment arbitrators. Because if we focus now on the investor arbitrators' accountability for applying the law, we see that investment law has evolved a lot over the 10, 20 past years, because it's a very, very new discipline and it's in flux. And states have become more aware of the obligations that are included in the treaties, and sometimes have been unhappy about the way investment arbitrators have interpreted the treaties. And we see a strong trend in newer treaties for more defined rules with clearer limits to the arbitrators' powers. We also see a trend towards providing specifically for contracting states to give joint interpretations of the meaning of the treaty. We also notice the opportunity for non-disputing states, that is contracting states that is not a respondent in the arbitration, to file submissions on the interpretation of the treaty, which, as I mentioned before, is also one of the contributions of the Mauritius Convention on transparency. So what we see is states giving more guidance or more instructions, if you prefer, to arbitrators about the application of the law. That is certainly a welcome development that all arbitrators would be happy to follow. Some say that judges are also accountable for independence, integrity, and competence. And that brings me to the second question about accountability. That is a more difficult one. To whom are judges, or to whom are investment arbitrators accountable? Or if you prefer, who controls them? And that's where we clash with judicial independence. I need not tell you that judicial independence is the bedrock of the rule of law. So there's a delicate balance between judicial independence and accountability. National laws and the legal framework for international courts attempt to handle this balance in more or less felicitous terms. They issues of appointment, compensation, discipline are probably the sorest pressure points in the tension between the two concepts. Because of the decentralized system of investment arbitration and because of the temporary mandate of investment arbitrators, what works for judges on permanent courts does not necessarily work in the same way for investment arbitration. Just one example, security of tenure is a vital guarantee for judicial independence, but there is no security of tenure for investment arbitrators. There are, of course, in investment arbitration a number of remedies to deal with this issue. A biased arbitrator can be disqualified. Certain institutions, not all of them, that handle investment arbitration can revoke an arbitrator who does not fulfill his duties, or at least cannot reappoint him the next time. For major procedural mistakes, such as a breach of due process, the award can be vacated. Is this sufficient? I am not certain, frankly. And it is clearly more difficult to discipline a core of a body of international investment arbitrators that function only temporarily, that is a diffuse body, is much more difficult than disciplining members of a permanent court. There are interesting attempts being made in newer treaties to address this problem by incorporating codes of conduct for investment arbitrators. You can see this in Canada, a European trade agreement, or if it ever comes to light, if the investment arbitration comes to light in this context, also in the TTIP. That is an area that certainly requires more thinking and more work, maybe by UNCITRAL. I started by saying that human rights, accountability, transparency, access to information are all present in investment arbitration. I trust that this very short review of this notion and of the presence of these notions in investment arbitration show a dispute settlement method that through challenges and trial by errors is progressively maturing. And in this process of maturation, I believe that the Mauritius Convention on Transparency plays a vital role. We all know that transparency will not happen overnight in every investment arbitration, but we also know that because of its symbolic value, the Mauritius Convention from now on sets the standard. Thank you for your attention.
Thank you, Gabriel. Now, I'm inviting James Costello to talk about the Mauritius Convention. James.
Good morning. Minister Bilum, Ambassador Bilum, Ambassador Han, Attorney General Yaragado, members of the Diplomatic Corps, distinguished guests, ladies and gentlemen. It is really a privilege and honor to be here this morning, and I particularly want to thank the government of Mauritius not only for its extraordinary hospitality in hosting this wonderful ceremony, but also for its vision and leadership in demonstrating that transparency is equally at home in Africa. And I also want to thank, I think on behalf of many members of the UNCITRAL Working Group, Mauritius for having bestowed upon the working group a native son of Mauritius, Mr. Salim Moulan, as our chairman, because it was really his deft leadership that got us through some of the toughest drafting sessions that I have seen in my 15 years as a delegate to UNCITRAL. I think in retrospect, we probably made a tactical error, and I've never discussed this with Salim, I don't know if he agrees, but I think if we had told the states who were members of UNCITRAL at the beginning of the Transparency Project that the reward for finishing the Transparency Project was a signing ceremony in the beautiful island of Mauritius, I think we actually would have finished our work probably probably in 6 months instead of 4 years. But it was an unexpected surprise at the end, and it makes the pleasure of being here all the greater. As Gabrielle has indicated, it really is a remarkable achievement, and it signals a big change, I think, in investor-state arbitration that we're here to mark. And I think I speak probably for many of the delegates of the working group that we, at the beginning of our project, when we took up transparency in 2010, there was really considerable doubt about whether we would come up with a final product at the end of this process. And I say that for 2 reasons. I think, first of all, there were many governments who were skeptical and who feared that mandating transparency would generally just expose them to unfair attacks by investor plaintiffs in public, which could greatly complicate their job of governance. And as someone who has spent about half of my professional life working in government, I'm very sympathetic to that instinct. But I think also that the governments within UNCITRAL ultimately came to see that keeping investor-state arbitration secret from the public actually created its own problems of governance, because, among other things, it provokes exaggerated fears about what is taking place behind closed doors. And my second reason for saying that I think many of us doubted whether we would wind up here today is that UNCITRAL operates on a principle of consensus. And so what we are marking here today is that virtually all of the states that are members of UNCITRAL have agreed on 2 things. First of all, that the transparency rules are the best and most balanced method of ensuring public accountability in investor-state arbitration while still protecting the rights of states as litigants. And secondly, that the Transparency Convention is the best mechanism for applying the transparency rules to arbitrations under existing investment treaties. And that is why we are here today. So I think the achievement of that consensus on these 2 points is really a remarkable thing. Now, I've been asked today to speak on how the convention and the transparency rules that the convention supports might redress some of the concerns that have recently been raised in the public debate about investor-state arbitration. And in order to do that, I think I need to spend a few minutes just reviewing what it is that the transparency rules actually do. If you go to the next slide. And so I'm afraid I'm going to subject you to a few PowerPoint slides because it seems like the easiest way of summarizing quite a bit of factual information. Before I begin, I need to make clear that although I've had the privilege of serving on the U.S. delegation to the UNCITRAL Working Group for the last 15 years, my remarks today are as a private practitioner, and they do not necessarily represent the views of the United States government. So I want to focus on 2 things. First of all, what are the main elements of the proposed UNCITRAL transparency regime? And secondly, which is my assigned topic, how the application of the Transparency Convention could redress concerns about investor-state arbitration. Next slide, please. So the first thing to know is that the transparency rules focus on 5 different domains of transparency, as I've called them. The first is that, so this is what tells you what will happen in an investor-state arbitration that is governed by the transparency rules. How will that procedure be different? What will happen? Well, the first thing that will happen is that all of the pleadings and submissions by the parties will be made public. Secondly, all the decisions and orders of the and awards by the tribunal will also be made public. The hearings during the arbitration will be accessible to the public. There is an allowance for participation by amicus curiae, third parties who claim an interest in the outcome. And lastly, there is a provision allowing what we call the non-disputing treaty party. It's the other state that has signed the investment treaty but is not a respondent in the particular arbitration. That state also has a right to participate. The rules then go on to provide exceptions to disclosure in order to protect confidential information, and they also provide for quite limited scope of application of the rules, which is why there was a need for the convention and why we're here today. So to look at the next slide briefly at these the 5 domains of transparency. With respect to submissions by parties and pleadings, we see that there are 3 sort of types or manners in which this disclosure occurs. For the bulk of documents like a statement of claim, a statement of defense, the hearing transcript, these will be automatically made public. And how is that going to happen? They are going to be transmitted after any required redactions to protect confidential information to a registry. The registry is currently a role filled by UNCITRAL itself, and they have established a website which is waiting for the first documents from the first case under the transparency rules to be forwarded to them, and these documents will be published on that website and available to the public. The second category is also automatic disclosure, but it's upon request. So the drafters recognize that witness statements and expert reports can be sometimes voluminous. They may not always be of public interest. But if there is a request by any member of the public to see them, then they too will be posted on this registry website. And finally, there's a category for discretionary disclosure. This pertains to what are often more voluminous documents that may be of less individual interest to the public, such as exhibits, which, as we know, can run to thousands of pages in a case. So, as I said, the first 2 categories will be published by registry on the web. And then also, for the next slide, please, we have a similar operation for decisions and orders and awards by the tribunal. These will also be forwarded to the registry and published on the website. Next slide, please. And then for hearings, saying that a hearing is accessible to the public doesn't necessarily mean that the public will be sitting in an audience in the same room as the tribunal and the lawyers. This can often be done by having a broadcast of the hearing by streaming through the web or other mechanism. This has already been done successfully in some industrial state arbitrations hosted by and it's been quite successful. Again, the rules provide for partial closure of the hearing to protect confidential information, and also if there's an unforeseen logistical problem. Next slide, please. I mentioned that there's a provision for amicus participation. This is subject to the discretion of the tribunal after consulting with the parties, and it's a decision that should be based on the tribunal's determination whether the amicus has something to add to the particular dispute. So, is there some factual or legal expertise that the amicus has that might otherwise be lacking in the record? If an amicus is admitted and allowed to make a submission, then there are a series of disclosure requirements for the amicus so that the parties will know, is it connected? Is the amicus connected with either of the parties? What are its financial sources of support? And so forth. And then, of course, the disputing parties in the arbitration have an opportunity to respond to whatever is submitted by the amicus. Similarly, and this is on the next slide, there's a provision for, as I mentioned, submissions by the non-disputing treaty party. So this would be the other country that is not a party in a particular arbitration, but the other party to the underlying treaty. And here that government is allowed to make submissions either on issues of treaty interpretation for the underlying treaty, or sometimes for factual issues that may come up which implicate that government's laws. And on that second prong, again, that's subject to the discretion of the tribunal, with particular attention being paid to avoid having states becoming essentially involved in diplomatic protection through arbitration. Then we turn to the exceptions, which is on the next slide, to transparency. Basically, the category of confidential information includes a number of different groupings. Information that's protected under the terms of the treaty, information that's protected under applicable law, information that might impede law enforcement. The redaction is to be done by the parties submitting the matter, but any disputes about the scope of that redaction are to be resolved by the tribunal. There's also a general exemption noted on the next slide when a state believes that disclosure of certain information might jeopardize its essential security interests. And finally, there's also a provision that says that if the state disagrees with the tribunal's decision that certain information should not be redacted, the state has the option of simply not submitting the document rather than having to disclose what it believes is confidential. If you go to the next slide, as I mentioned, and this was touched upon by Ambassador Hahn in his remarks this morning, the scope of the rules application is limited because we realized that in existing treaties where a state has, for example, said it is willing to submit to arbitration of the UNCITRAL rules, we can't suddenly now wave a magic wand and say that when the state agreed to that, they actually also agreed to submit to the transparency rules, which probably no one even envisioned at the time that the treaty came into force. So the rules themselves are limited to only applying to arbitrations under future investment treaties, those signed on or after April 1st of last year. And that is why the convention came about, because the convention allows states to commit to applying the transparency rules under their existing treaties. And as long as the other treaty party or the other arbitration party in a particular arbitration have also agreed, then the transparency rules will apply to arbitrations under the existing treaties. Now, against that background, my topic is why do I think that a general application of the convention could redress some of the current concerns about investor-state arbitration. As many of you have undoubtedly noticed in the press, we have an unusual convergence of negotiation of three major multilateral trade and investment treaties. What is known as CETA, which is the Comprehensive Economic and Trade Agreement proposed between Canada and the EU, the TPP, which is the Trans-Pacific Partnership and is between the United States and an array of Asian countries, and the TTIP, which is the Transatlantic Trade and Investment Partnership between the United States and the EU. And each of these draft agreements, like about 3,000 existing investment treaties, contains a provision for international arbitration to resolve disputes between investors and the host country. And so the proposed adoption of these treaties has triggered a broad debate, particularly in Europe, about the value and the legitimacy of investor-state dispute resolution, what is often referred to as ISDS. S there standing for settlement. So what I have done today is I've highlighted four of what I think of as the recurring themes of criticism that one reads, and here I've confined myself to just the business press. So this is more or less the mainstream press talking about the debate on investor-state arbitration. And I'm not trying to take a position today on the validity of these treaties, whether it's a good or a bad thing to adopt TTIP or to adopt CETA. And I'm not even taking a position on whether the existing investor-state arbitration provisions in those treaties are fine as they are, or whether they require revision, as some governments have now said. My main purpose this morning is simply to suggest that many of the criticisms, I think, so far have been based upon a lack of knowledge about investor-state arbitration. And there's a fear and suspicion about what is unknown. And so the point I want to make is that if all of the pleadings and all of the hearings and all the decisions and awards by tribunals in these arbitrations were actually publicly known, I think the debate we would be having would be very different. And my own personal view is it would be a better debate, because I think instead of arguing about what we don't know and what we fear is going on behind closed doors, I think we could have a debate about the actual results of investor-state arbitration. And my suspicion is that some critics might find that they have less to complain about if they were actually looking at the actual process as it unfolds. So let me just take briefly these four themes that I've identified. On the next slide, I've just taken a couple of quotes from a recent issue of the London Economist not generally known as a publication that's anti-big business, but nevertheless, here's what they had to say about the secrecy of the process. Could we have the next slide, please? And so they said that the manner in which investment disputes are being resolved is all the more galling because the proceedings are not open to the public. And then they say, it's no surprise that many people believe ISDS stacks the rules of globalization in favor of big firms. What's interesting about this is that they don't say, the Economist doesn't say that in fact the rules are stacked against, in favor of globalization and large firms. They say that many people believe it, which is not a particularly useful way for a news magazine to start the debate, but it is very much based on fears as opposed to a study of what the cases actually hold. And then they go on to say that the secretive nature of this process allows plenty of scope for creative adjudications. Again, the Economist doesn't point to particular adjudications which they feel were unduly creative, but rather they simply say that it allows for that without giving examples of troubling results. If we turn to the next theme, which is on the next slide, recently one of America's most prominent senators, Senator Warren from Massachusetts, published an op-ed article in the Washington Post in which she denounced the TPP, the Asian trade treaty that's under discussion. And she said that the ISDS could lead to gigantic fines, but it wouldn't employ independent judges. Instead, highly paid corporate lawyers would go back and forth between representing corporations one day and sitting in judgment the next. If you're a lawyer looking to maintain or attract high-paying corporate clients, how likely are you to rule against those corporations when it's your turn in the judge's seat? Again, this is framed in an entirely speculative way, a speculation about how likely it is that an arbitrator will rule in a certain way, rather than talking about what the actual outcomes are. And in fact, as we know, there are many arbitrators who are actually appointed both by investors and by states, and we also know that there are many counsel who both represent states and also individual investors, depending upon the particular case. Now, I'm not saying it's always that way, but I'm saying that the record is somewhat different than from what the suspicions are being sowed here. And again, I think it would benefit if the public were actually able to see clearly what kinds of decisions are rendered by these arbitrators in fact. One thing I might mention here, and it goes to the question of, could we stay on the prior slide for just a moment? It goes to the question of corporate lawyers. It's a very broad term, of course. What's often been said in the ISDS debate is that it would be preferable to have national judges resolving these kinds of investment disputes. I won't pick on any other country, but I would just say that I have very, very high regard for the federal judiciary in the United States. But if you were to take a survey of all the federal judges in the United States and find out what their knowledge of international law was, you would be really surprised at how thin it is. And by contrast, a number of the arbitrators who sit in these investment cases actually have had experience and know quite a bit about international law. Some of them have served in public positions for their governments over the years. And so it's, again, the situation is a bit more nuanced, I think, than the criticism has suggested. If we go to the third theme, which is that ISDS facilitates attacks on environmental, social, and consumer protections. Here I've taken a quote from Le Monde, and what's I found particularly interesting here is that they talk about how, in fact, these protections, the whole process of investor-state arbitration was designed to deal with abus de droit. And then it goes on to say, but in practice, many decisions have placed in question legislation on environment, social legislation, and health legislation, which are contrary to the interests of certain businesses. And then it goes on to equate that by saying Germany has thus been attacked for having decided to get out of the business of nuclear energy, And Australia similarly has been attacked for its tobacco policy. What's interesting there is that you see that the first sentence is about saying that many decisions have threatened existing environmental and health legislation. And then it goes on to only mention 2 cases which have recently been filed. In my own country, I must say that there's almost never a major government policy that's announced that someone doesn't sue to try to overturn. I think the question is what will be the outcome, not whether a suit has been filed. A recent paper by the Columbia Center for Sustainable Investment noted that only a tiny fraction of investor cases in which the investor actually won involved legislative measures as opposed to individual decisions by the executive. The last theme I would go to is that it guarantees payments to corporations whenever host government policies reduce their profits. And here I have a quote from the business editor of Der Spiegel, and she says that under the way it would work, she's discussing the ISDS provisions of TTIP, is that the arbitration court would have the power to make rulings on huge damage payments if any investor believed its profits were reduced. But of course, and Gabrielle touched on this in her presentation this morning, what really matters is what are the standards for investor protection. What an investor has to demonstrate is that the standard of fair and equitable treatment or the standard of protection of investment have been violated in some way, which typically involves having to show discrimination or arbitrariness. It's not enough to just show that your profits have gone down. But again, this quote doesn't point to any real cases. It simply excites concern about what is happening behind closed doors. My last slide is simply to say that in general, I think that the transparency bug may be catching, and I think it may be expanding to the overall treaty debate, which is that here's a recent quote from an article in the Financial Times, which is that the entire TTIP debate has now become caught up in the question of transparency. So quite apart from the investor-state arbitration part of it, but just the overall text of the treaty. And the EU, in an attempt to rebut charges that the whole treaty was being negotiated in secret, has published 8 of its negotiating proposals. And this is the first time that Brussels has ever published specific legal proposals while an agreement was being negotiated. And there you see a quote from the EU Trade Commissioner saying it's important that everyone can see and understand what we are proposing and what we are not proposing. So I think in general, if we had more transparency, we would have fewer fears based on things we don't know, and I would hope more debate about the things we do know. Surely there is always room for criticism of the existing process, but I think we would be having a debate about what the real outcomes were and which ones were disputable, which ones were acceptable, rather than worrying about what we don't know. Thank you very much.
Thank you, James. Well, ladies and gentlemen, we've had a fair share of a lot of nice things about state investor arbitration. The floor is now yours, should you wish to intervene or ask any questions to our very eminent personalities here on the panel. The floor is yours. Salim.
Thank you very much. Maybe just to trigger something. Jay, perhaps a question for you. Where do you see the more global debate about the standards of investor-state arbitration going? And by that I mean, I understand that some states are now thinking of renegotiating their treaties or having new treaties that will have more defined standards. So we're now more into the substantive issues. But do you see that as the way forward, or is it going to be more process-driven, as what we have done with this convention, in terms of maybe establishing an appellate mechanism to try and get more coherence between decisions? I know it's a very wide point, but I think one which we would be interested to hear about.
Well, it's a very good question, Salim, and I'm not sure I exactly answer. It's definitely true that one hears, even in the last few months, more discussion of country saying, I would like to take what is a broad standard like fair and equitable treatment, and I would like to make it more specific. I think that before we do that, probably it's useful to look at particular examples, and of course, through websites which the public doesn't normally consult, websites which are known to arbitration specialists and which are public. There are a number of arbitration awards that have become a matter of public record. And I think it's probably useful to look at particular examples and say, all right, well, how would we tighten language that might exclude a result which we all agree was not intended or is acceptable. I generally think it's very easy to say that the standard is vague, but at least from my own background as an American lawyer, and I suspect that other people come from a similar tradition, if you look at some of our standards of, for example, constitutional guarantees, a phrase like due process is an extremely vague phrase. It might be attacked as being very vague, but in fact, over the years, that flexibility has allowed the court to adjust what due process means to the prevailing circumstances as times have changed and as the factual situations that the court confronts have changed. And therefore, there is probably something to be said for not automatically assuming that a broad phrase like fair and equitable treatment is automatically bad because it is flexible, because I think it's more useful to look at whether it actually leads arbitrators astray to decisions which most of us would consider unfair or unwarranted. But you're right that there is a move in that direction.
Gabriel, do you want to intervene on that?
No, I would just add to what Jim said, that the evolution is on both fronts, I believe. If we look at more recent treaties, there is certainly attempts to make investment arbitration better workable, better acceptable by procedural guarantees and procedural arrangements, and at the same time on the substantive level of the guarantees that are being provided. So I think one does not exclude the other, and it makes sense that the international community continues working on both fronts.
Honourable Minister of Foreign Affairs.
Thank you. Two questions, primarily to Jim Castico, but also to any other member of our panel. The Mauritius invention is seen as a good start, but many observers, enlightened observers, say that there is room for broader reform in treaty-based investor-state arbitration. To what extent is that right, and how can we progress further? That's the first question. The second question is that there is room to progress, to move beyond investment treaty disputes, to go to investment state disputes arising out of contracts. We are now only in the realm of treaties. What about contracts which also involve so many billions of dollars of disputes? Thank you.
Sure, well, I'll start off with that and move on to the microphone. On your first point, Mr. Minister, I guess I may be accused of a lack of ambition here, but I guess my feeling is that today I understand there may be 8 governments that signed the Mauritius Convention. In order to make this whole regime really effective, we need to have a lot of governments. So for myself, I think of the next goal as not moving on to another reform project yet, but rather trying to get a critical mass of governments to sign this convention, because that will really make the transparency regime workable and something that everyone recognizes. On your second question, it is an issue that has been raised. Why stop with treaty arbitrations? Why not go on to other arbitrations that involve state entities as a party? We confined ourselves to treaties for, I think, a number of reasons, but one of them was that we recognize that with treaties, you are almost always talking about an issue that has some public policy interest. That's not always true of a case which has a state entity involved. I myself have represented both states and investors or project contractors in cases that involve a road project, and there isn't any particular public policy involved. It's just a road project that may end up having a contractual dispute, as construction projects often do deal with disputes. So I mentioned that just because we all recognize that there is some cost to having transparency, for sure. It's going to add expense, just the time of the lawyers to deal with new submissions of amicus, to deal with reviewing and redacting material for confidential information. All this imposes some cost, and the question is, what's the corresponding benefit that justifies that? In the case of treaty arbitration, we thought that was clear what the public benefit was. If it's a road project with a state road authority, it's probably less clear, so it's subject to discussion, I think, in debate.
Thank you, James. Michael, perhaps want to come.
I agree with James on this idea that perhaps it's a bit early for Concentrol to begin to develop new projects. But where I disagree, again, is the idea of suggesting that the Concentrol Convention on Transparency is that radical and is that new. Traditional dispute settlement mechanisms have always been transparent. Access to documents, access to information, participatory processes. It's been very traditional part of the rule of law. So asking for investment tribunals to do the same seems to me not radical. So there's nothing new about that. The point, of course, is that there is a lot more that traditional dispute settlement mechanisms do already, which I think arbitration tribunals could also take to. So we ought to be looking at an effective system of dispute settlement. And in that respect, there are many possible ways in which we can improve dispute settlement systems, including arbitration. And of course, not necessarily to formalize the process into another project, but asking arbitrators to begin to insert aspects of good practice into some of the process. And then once there is sufficient comfort and state practice on it, well, you can write that into another treaty if necessary. So I can see the need for further development, i.e. this treaty alone is not enough to think we're getting with that. But it's a great step ahead, but there's room to do more.
Please.
Thank you, Honourable Minister. Thank you very much.
Sorry, Minister.
May I?
Yes, you may.
Thank you, Honourable Minister. I'll give the floor to the Chairman of the Constitutional Minister of the Commission.
Thank you for your courtesy, Mr. Chairman.
Thank you for the all panelists. It's very informative and good start for our first round of discussion. I have 2 or 3 different questions. Regarding the first one is, it's just the general public's point of view. With this transparency convention, what you can expect future development, whether this transparency convention is helping investor side or state side, or whether this convention will promote further agreement with treaty on investment side. So I'd like to see how this convention will affect overall arbitration world as well as or general ordinary public's interests. Second question is you talk about maybe James talk about exception on transparency with some confidentiality as well as state national security issue or interest. So in that case, who will decide this confidentiality with which criteria? So that could be a question. And third question is you talk about This Transparency Convention will affect a discussion on 3 ongoing multilateral, arrangements like CETA, TPP, TTIP. Particularly, I'm interested in TPP because, Korea is located in the Pacific Rim. Do you elaborate a little bit more, how this Transparency Convention will affect, TPP discussion on this particular arbitration area? Thank you very much.
Thank you, Ambassador. James? You would very well solicited all. Gabriel. Gabriel.
I can take the first question if you wish, Mr. Ambassador. It is indeed a very challenging question, and it will be easier to answer in 5 or 10 years from now. I don't think we have fully grasped yet what this convention will do to investor-state dispute settlement. It is not favorable to investors or favorable to states. It is neutral in its operation. But what will the public knowledge about how these processes work change to investor-state dispute settlement? That I'm not sure of yet. It could well be, and that this will trigger other reforms on accountability of arbitral tribunals. For instance, as I mentioned, on issues of consistency. Right now there are decisions that go one way on one question, another way on another question. This is of course known to specialists, but if the whole operation behind the result becomes known, maybe this will trigger other reforms. It will certainly also alleviate fears and concerns, because people will see that there's nothing exceptional. This is just justice administered as we are used to, except that in a special context, but there's nothing special about investment arbitration compared to how an international court would function. So it is an open question to see how what effect it will have, certainly to alleviate concerns, I do.
Michael?
I think this is quite an important part of what public image is of transparency convention. It seems to me it's the way we sell it, the way we present and disseminate it. I think really to disseminate it as adding this extra value to the effectiveness and legitimacy of the process is always a good one. But it's not going to be instantaneous. It seems like turning a super tanker around, and it will take a while. But it needs a lot of buy-in into the process. And I have a very interesting analogy when the United Nations mentioned or began to talk about human rights in business. The initial reaction of business was to object when we had something called the United Nations norms. Business essentially lobbied to kill it, and they did successfully. But once they had the Secretary General and the Special Representative who took an entirely different approach to marketing, because he went there with a blank slate and asked businesses what they thought they ought to put into it. And rather ironically, rather shockingly, they asked for exactly what they had rejected. And so the process of consultation, the process of getting them to buy in, really made a lot of difference. So if we are able to market this transparency convention, I think the chances are that it will be received very fully. I can see little bits of the process and the rules that people will sit down and think, well, it is now in the rules that if you want information, you pay for photocopying. For God's sake, how much is photocopying? Why should we write it into a document like this? Oh, this must be because it suits business. Well, no. The truth is that it costs money. And if you want 2,000 pages of documents, someone's got to pay for it. And we need to be able to market it as realistically as possible. To say it's not because we want to favor business that we're asking for you to pay for the photocopy. But it's a hell of a lot of money. You want to pay for it. And little things of that sort. And the question of reduction will also raise, no, but this is because business is also going to high. Well, put yourself in the position of business, and there are competitors out there. It's a very dire market out there. How much information do you want to put out there so that these competitors will kill his business? No, these are real factors that we need to communicate out there. And once we communicate it, I think it becomes very clear that this will be received and received very well, without suggesting
thank you, ladies and gentlemen. Sorry, James. Sorry, I didn't see
I
you.
just, there were a couple of questions that I think might have not been answered. On your question about how is a determination of confidentiality made, who makes it, under the rules, it's always the tribunal, and the tribunal will apply the language that's in the rules about what the different categories of confidentiality are. So it's up to the tribunal to apply that language. I just, on the question of TPP, I really feel that I am so far less qualified than you are, sir, to talk about what the impact in Asia might be. I would simply say that I think that if it were assumed, I think at the beginning of the debate, that transparency might be a part of these new multilateral instruments, I think that the debate about the investor-state arbitration provisions would be different, because I think that if people understood that there was a baseline assumption that these proceedings would be public, then I think we, as I said, I think we'd be having a different debate. The last thing I just add to what Gabriel and also Michael said about does it favor investors or does it favor the government? I don't want to get in trouble with the Attorney General for suggesting something to his staff. He may hate me for the rest of my life, but I had the privilege of working under the Attorney General who served under President Clinton for several years. Her father was a journalist, and so she declared on her first day in office that she was going to hold a press conference every week. Now, her staff just tore their hair out. They thought this was the most idiotic idea that the Attorney General could ever have, because there are so many things in the Department of Justice that you really cannot talk about because it's an ongoing investigation and so forth. But she really believed it, and so what Michael was saying is true. She presented it as something that was important to the public to have confidence in the Attorney General. There were many, many times in her weekly press conference where she was obliged to say, "I'm sorry, I can't comment on that, it's a pending criminal investigation." But I think over time, the public actually became more confident when she, for example, confessed that she made a mistake, or she said that something had not worked out the way she thought it was going to be. And the only point I wanted to make is, I think it is actually, having seen it from the inside, it is more difficult for the government than it is for the private sector party to adapt to a new regime of transparency, because the government has to go through usually a clearance process internally to be able to publicly disclose a position which has gone through a lot of vetting. A private sector investor is usually much more free to adopt a position and publicly proclaim it. So I think it's probably more difficult on the government side, but on the other hand, I think the government has unique benefits which no one else has from legitimacy. It's exactly the point that Michael was making. Legitimacy of the process of knowing that now the government's position is in the public domain. I hope that is responsive to you.
Thank you, James. Well, ladies and gentlemen, I think allow me to thank all the eminent members of the panel and thank you for your kind intervention. I think this is a convenient time for us to break for lunch, and we will resume at 2 p.m. Thank you. Enjoy your lunch. Bon appétit.
We have the honor to invite Honorable H.N. Sinatapu, Minister of Foreign Affairs, Regional Integration, International Trade, to address you. Honorable Minister.
Thank you very much, Ambassador Dillon. Good afternoon, everyone, and welcome to the afternoon session, to the first session of this afternoon's meeting. Now, I know it is quite difficult after lunch to keep one's concentration, and therefore I have impressed upon the two speakers that they should be sure that they actually raise your enthusiasm to its maximum. What I have to propose to you is the theme of the development of arbitration at regional levels. Now, earlier this morning, we heard from my colleague and good friend, the Honourable Minister of Financial Services, Good Governance and Institutional Reform of our motherland, how there appears, without any contentious issue being raised, but there appears to be some sort of imbalance when you look at figures. In other words, if you look at the figures insofar as arbitrators are concerned within sub-Saharan Africa and the Middle East, you have about 2% of individual arbitrators, whereas the number of arbitral cases for the region is about 27% of the whole of the totality of arbitral cases. Now, there is therefore an argument for regionalizing arbitration, and this is what we are going to be delving into this afternoon, within, of course, the 75 minutes allotted to this panel. Now, in this respect, I have the pleasure of having two panelists with me. One is Duncan Bagshaw, who is a barrister and the registrar of the Arbitration Center, which has an acronym with 8 letters. I must say that I didn't have a clue a year ago what LCIA MIAC stood for. So I've made sure, that now I know it is I speak of the correction gentlemen, it is the London Court of International Arbitration, or London Centre. It's called the Centre. It's the London Court of International Arbitration, and then Mauritius International Arbitration Centre. And Mr. Bagshaw is the registrar, and according to the head of the Secretariat of the Arbitration Centre. Duncan is responsible for administering cases under the LCIA and IAC arbitration rules and other arbitration rules, including the UNCITRAL rules. I understand that Duncan has also been responsible for promoting and developing the LCIA and IAC since its inception in 2011. Now, I understand you're going to address us this afternoon on the topic of places for regional arbitration and the experience of Mauritius. Now, our second speaker is going to be Dirk Burkowski, who is a senior legal counsel of the Permanent Court of Arbitration. He is currently the Mauritius representative of the Permanent Court of Arbitration in this country, and he heads the permanent office of the PCA in Mauritius. Now, I think I can say that we take great honor to be the only country to host another representation of the PCA in the world. And Dirk is going to speak to us on the topic of taking ownership, investment arbitration in Africa. So, without further ado, I will invite Duncan Bagshaw to address us on the theme Places for Regional Arbitration, the experience of Mauritius. Over to you, sir.
Thank you very much, Honourable Minister Sindakofu.
Honourable Attorney General, Honourable Under-Secretary General for Legal Affairs and Legal Counsel of the United Nations, Honourable Chairman of UNCITRAL, Excellencies, distinguished delegates, ladies and gentlemen. It is a great honour for me to have been invited to speak at this momentous conference on the occasion of the signing of the Mauritius Convention on Transparency in Treaty-Based Arbitration. It's also a great thrill for me that Mauritius was chosen as the venue for the signing of this treaty. I have lived in Mauritius for about 3 years since I came to take up the post of Registrar of the LCIA MIAC Arbitration Centre
and I do apologise to the applicant. We usually say MIAC, which is much less of a mouthful and easier to remember. I'd never visited Mauritius before I arrived to live and work here. Unlike the many tourists who come to Mauritius, I came to Mauritius as a place to live and to do business, just like an increasing number of companies and investors do from around the world. I recall arriving from the United Kingdom for the first time early in the morning with a thick blanket of grey cloud covering the island, the rain coming down in torrents, and I distinctly remember feeling immediately at home. I hope that your visit to Mauritius has allowed you to see some of what has made the experience such a pleasant and fulfilling one for me, if only the beauty of the country and the warmth of the Mauritian people. The second great joy for me of being in Mauritius has been the opportunity to be part of an unprecedented and visionary project to create, almost from a standing start, a place and venue for international dispute resolution which ranks amongst the major centres of the world. My task today is to give you some flavour of the experience of Mauritius as an emerging venue. I hope that many of you will have witnessed for yourselves in written reports and in person some of the progress that we've been making. Honourable Minister Badad has already set out some of the important steps in his opening address which have been taken by Mauritius, and Honourable Minister Sidatombo in his earlier address has explained how important the Mauritius Convention on Transparency is to the vision of Mauritius as a place of trade and international exchange. For my part, I'm going to first examine in a little more detail some of the legal steps which have been taken in Mauritius and the importance of the work of UNCITRAL to the Mauritius project, before moving on to offer some of my experiences in seeking to advance the project internationally and the reception that the project has received, particularly in Africa. I will speak mainly about the law of Mauritius on international arbitration, and I appreciate in doing so that that law has the closest connection with international commercial arbitration rather than investment treaty arbitration. Most investment treaty arbitrations are not subject to any national arbitration law. However, that is not to say that in arbitrations involving states or arising out of treaties cannot be resolved by international arbitration under the rules of an institution, even one more generally used for commercial arbitration like LCIA and MIAC. And that's not to say that international treaty arbitration cannot be resolved under the law of a particular jurisdiction as the seat. Indeed, I recently had cause to review the model bilateral investment treaty template of the Southern African Development Community, of which Mauritius is a member, which was adopted in 2012. That document provides for the parties to a BIT written in the model form to select from the alternatives of ICSID arbitration, arbitration under the UNCITRAL arbitration rules, or the rules of another agreed institution, and in such a case to provide for a chosen seat of arbitration. The official commentary on the model BIT template says that where a regional forum for arbitration exists that may be able to provide the appropriate rules and facilities, and I quote, the drafting committee was of the view that it should be carefully considered for inclusion or as an exclusive option to be used. There remains clearly a significant challenge for institutions such as LCIA and MIAC to ensure that they have the appropriate rules and facilities for handling investment treaty cases. But the SADC model bilateral investment treaty shows that that is an area where attention is needed because countries in Africa, and I dare say in other regions of the world, particularly the developing world, are increasingly seeking to have regional institutions and regional venues host investment treaty arbitrations. One can also acknowledge the possibility of national courts and national laws being engaged in investment treaty cases. I recently was reminded of an Indian case called the Port of Kolkata and Louis Dreyfus Armateur. That was a case in which the court granted an anti-suit injunction restraining the defendant from pursuing an investment treaty claim, and that was a court in India. It's wrong to ignore the importance of good national laws and good, effective national courts in relation to treaty arbitration. When the Mauritius project was begun in around 2006, the law governing international arbitration was found in the Mauritius Code de Procédure Civile, which mirrored the old French law on arbitration before the modern refinements that had come into force. Mauritius considered adopting the UNCITRAL model law without any amendment. However, the drafters of the Act considered that some departures could be made from the raw text of the model law without departing from the fundamental principles that underlie it. That was partly possible because of the unique legal heritage of Mauritius, which is a hybrid legal system between English and French law. It was also because of the particular motivation of Mauritius to be innovative in making the law as supportive of arbitration as possible. As the Honourable Minister observed earlier, the aspects of the International Arbitration Act, which was adopted in 2008, which depart from the model law's original text, include provision for the role of the PCA and provision for a special panel of 6 designated judges of the Supreme Court to hear all matters under the International Arbitration Act, sitting as a bench of 3 judges. It's worth noting, though, and acknowledging UNCITRAL's work in that, whilst Mauritius was fairly avant-garde in including these innovations in its Act, provision for that sort of creativity was already is included in the UNCITRAL model law. Article 6 allows the enacting state to designate the authority that deals with the matters that the PCA deals with in Mauritius largely. And the definition of court in the model law allows the enacting state flexibility to decide which court is going to make decisions under their International Arbitration Act and what route of appeals will be available, if any, which allow the Mauritian solution of a 3-judge bench and an appeal as a right to be available to the Privy Council in England and Wales. Other important work of UNCITRAL is also reflected in the Mauritius Act, going beyond that in the UNCITRAL model law. The UNCITRAL arbitration rules, which are frequently agreed upon to govern disputes between states and private persons, are reflected in the Act in various instances. Some examples include the additional clarity that's provided in the Mauritius Act in relation to the service of documents by electronic and other immediate means. Secondly, a provision which provides that all awards are deemed to have been signed at the juridical seat of the arbitration, which was added to avoid any potential problems with awards signed in multiple locations or signed at locations other than the seat. That update was included in the 2010 UNCITRAL rules, but previously had already been brought into the Mauritius Act. Thirdly, the provisions dealing with the appointment of arbitrators when there are more than 2 effective parties who have to form sides in order to appoint arbitrators in the traditional way. The Mauritius Act draws heavily on the UNCITRAL rules in order to avoid the so-called duck code problem of a lack of legitimacy in the appointments as a result of there being multiple parties. And finally, the provisions which deal with truncated tribunals. In other words, what happens if an arbitrator is removed, whether an arbitration can continue, and whether it should continue with a replacement, and how that replacement should be made. Other aspects of the Mauritian Act draw on other countries' legislation. For example, Schedule 2 to the Act, which is an opt-in part of the Act, it only applies if the parties specifically agree, is drawn from the New Zealand Arbitration Act and deals with appeals on points of law, consolidation and joinder. Section 5 of the Act, which deals with the court's power to stay any court proceedings where it is asserted that the dispute is covered by an international arbitration agreement, draws heavily on the new French Code de Procédure Civile for its wording, which provides clearer guidance for the courts on how to resolve disputes over whether a particular case is governed by a valid and binding arbitration agreement or not. The International Arbitration Project in Mauritius has another key quality, which is that it hasn't simply been a single step change in the system, enacted all at once. It's been an ongoing evaluation of the system and how it can be improved and how it's working. The travaux préparatoires to the Act include an exhortation to practitioners, academics and others to report back to the government of Mauritius on how well the Act is working in practice and whether they have any proposals that could be made to the system in order to improve it and make it clearer. And indeed, in 2013, Mauritius put in place a series of legislative refinements and a new procedural system in courts. One very important change that was made was that the reciprocity reservation was removed from Mauritius's adoption of the New York Convention. In terms of being an inclusive centre for international arbitration, particularly in Africa, that was a very important move, both symbolically and practically. Whilst 33 countries in Africa have adopted the New York Convention, there remain 19 countries that have not. So removing the reciprocity reservation, enforcing awards whether they come from a country which has or has not adopted the convention itself, it is of great value. This year Mauritius has made a further change, not to the laws governing international arbitration as such, but to the system of regulation of global business companies, which are incorporated in Mauritius to do international business. Those companies are subject to a system of regulation and licensing. That system of regulation has, since this year, recognized a company which provides for disputes arising out of its constitution to be resolved by arbitration in Mauritius, which tells us two things. First of all, that Mauritius has adopted and put into effect a provision in the International Arbitration Act that says that such strictly company disputes are arbitrable, which they're not in every jurisdiction. But secondly, that the regulator has acknowledged the importance of companies which engage with the international arbitration system and said that he will give credit to companies, he will acknowledge that they have shown an engagement and substance in the Mauritian jurisdiction if they provide for that arbitration with a Mauritian seat. Before leaving Mauritius specifically, I would like to say a brief word about the judiciary of Mauritius. It has been an essential part of the progress that our project has made so far, that the judiciary of Mauritius, both in court and out of court, are engaged and interested in both the legal developments that have been made and the importance of international arbitration for Mauritius as a jurisdiction. We've seen, both in and out of court, that enthusiasm and engagement. In court, the judge of the Supreme Court of Mauritius, sitting, as I've said, as a panel of 3 drawn from 6 specialist judges, has handed down a series of trenchant and insightful judgments which have applied international arbitration law in a way which I suggest shows an understanding of the principles that underlie it. A particularly important judgment is a recent case called Cruise City 1 Mauritius Holdings against Unitech. Various technical points were made in that case, but the big one was that the whole enforcement system of international arbitration, international arbitral awards in Mauritius was unconstitutional and contrary to the provisions of the Constitution that relate to the courts. Those kind of challenges are not made often. They may not, you might think, have much force to them, but when they are made, they need to be dealt with utterly comprehensively to avoid any doubt going forwards about the position under the law of that country. And if you read that judgment in Cruise City, you will see the way that the court dealt with that case. Outside of court, the judges have attended our conferences, they have spoken at our conferences, and they have been extremely open and willing to engage in discussions with me and other colleagues on the subject of international arbitration, and I commend them for that. But establishing a new centre and venue for international arbitration proceedings is a very long process. The elements that combine to make sure that that is so are probably apparent to all of you. The lead time between contracts being entered into, treaties being signed, and cases arising is very long. 1 year is realistically the minimum period that one could expect. The gradual process of building awareness on a global scale, which is necessary to have a realistic chance of being chosen by investors and investor states or 2 parties from different continents, takes a great deal of time. And the multiplicity of parties and stakeholders we often get in significant arbitration cases makes it very difficult to get everybody to agree to the same thing, unless it's an old, established place which they've all agreed to many times before. That has the difficulty of perpetuating the inertia of very old, established venues and preventing the development of new ones like Mauritius. We try to address that by being extremely comprehensive in the work that we do in raising awareness, not limiting ourselves to one country or one continent, not limiting ourselves to governments, corporations, private practice lawyers, or the public sector, NGOs, but trying to contact all of those groups. It's also very relevant that Mauritius has not simply sought to turn the domestic arbitration scene into a commercial international arbitration centre, let alone an international investment treaty centre. Many arbitral centres begin as domestic centres and busy venues for domestic arbitrations and develop from there into international centres. Rather than doing that, Mauritius decided that it would put in place a specialist international regime, thereby recognizing the profound distinction between the two types of dispute resolution. The fundamentals of an international dispute resolution process have to reflect that distinction, particularly when handling cases involving governments, because of the way that government interests go beyond commercial concerns and include more complex motivations such as the well-being of their people, concerns of national policy, economic stability, and their relationships with other nations. It's for that reason that in Mauritius we have always pursued the project from the point of view that international arbitration requires special, dedicated provision. The Act, enacted in 2008, deals only with international cases. The role of the PCA, an intergovernmental organisation, which is given a role under the Mauritius Act, also reflects this. And the establishment of LCIA MIAC, the arbitration centre of which I'm the registrar, has also been done in a way that ensures it is truly international. The structure of the organisation makes it essentially Mauritian. It is a Mauritian company, but with the involvement of the LCIA, it has an international board of directors, and as you heard earlier from the Honourable Minister, the LCIA takes the lead in relation to supervising the administration of cases and ensuring that they are done in a completely neutral, independent way, and one which meets the standards of the major international institutions of the world. All of this means that we cannot be expected to make the leap to becoming a busy international centre overnight. Fortunately, that has always been recognised by the stakeholders in this project, in particular the government of Mauritius, meaning that the growth of Mauritius as a venue has sensible, long-term support. And I was particularly pleased to hear the acknowledgement by the Honourable Minister this morning that a new hearing centre, which we have been waiting for in Mauritius, is going to be put in place in the coming months. That sort of provision is essential for those parties looking for a quality venue for their hearing, regardless of their origin. Over the last 3 years, I have visited 16 African countries and a number of other countries across the world, and had meetings with, as I say, government representatives, lawyers, companies, NGOs, and a raft of different groups, and assessed the response to Mauritius. On the whole, it has been very positive, because Mauritius is essentially seen as an African country. It has a history which shares certain features with other countries in the continent of Africa. It has been a colonial territory of the United Kingdom and France, and it has a population whose heritage is African to a significant extent. The strongest message which comes out of my experiences is that African parties want, as far as possible, to have African disputes resolved in a relevant local venue or regional venue and with African participation. And I would refer back to the preference of the drafters of the SADC Model BIT for a suitable regional forum where available and where appropriate. In Mauritius, we're acutely aware of the need to maintain the balance between excellence and the perceived neutrality that African and other developing world parties seek. We believe we're making a real contribution to it with the quality of the framework that we've put on the ground here, and the availability of the venue in an African jurisdiction which represents no compromise on that quality in terms of a hearing venue, the selection of arbitrators, and the quality of administration of cases that can be expected. The platform here in Mauritius does appear to be gaining traction with African governments and other organisations. As I say, the response from African governments has been extremely favourable, and it has been made clear to us by representatives of governments that Mauritius is a preferred venue for them, where their own jurisdiction as a venue isn't considered acceptable to all the parties. Outside of the strictly public sphere, the African Development Bank published a report in 2014 in which it found that LCIA MIAC and Mauritius were suitable venues, satisfying all of its criteria for arbitral venues in contracts which it has funded for dispute resolution and international arbitration. We have always tried, in everything we have done, to ensure that we collaborate as far as possible with other institutions in the African region. We've supported conferences held by the Kigali International Arbitration Centre, the Lagos Court of Arbitration. We recently provided guidance to the Nairobi Centre for International Arbitration on the establishment of a new arbitral institution in Kenya. I'm going to be speaking shortly at the East Africa Chambers of Commerce Conference in April in Dar es Salaam, and I'm sure there will be reference made to the plans of Djibouti, which recently announced that it will open a new international arbitration centre planned for 2016. Very importantly, we've also always invited institutions across the continent to participate in the extensive programme of training and education that we've put in place. They have attended the MIAC conferences in 2010, 2012 and 2014, and the major African institutions will be invited to be represented at ICA 2016 when it takes place in May next year here in Mauritius. Registration fees for that conference, very importantly, will be subsidised to increase accessibility for African participants. That spirit of cooperation flows naturally from the overall mission behind the project. We believe that Mauritius can lead the development of a skilled, knowledgeable African body of arbitration experts, both in investment treaty and in commercial arbitration. And we believe we have the potential, against that background, to be an active and popular venue for international arbitration proceedings of all types, whether administered by LCIA MIAC or other bodies who choose or whose parties choose to hold hearings in Mauritius. As a result, we hope to make a real contribution to maintaining and improving the perceived legitimacy of international arbitration proceedings in the future. Thank you very much.
Thank you very much, Duncan. Now, as you will have heard, Mauritius has been doing quite a lot in order to try and become a centre of excellence for arbitration matters. I think that it's good to observe that the fact that the only permanent office of the Permanent Court of Arbitration has been here since 2009 speaks for itself, and our linkage with the London Court of International Arbitration, one of the oldest and most respected arbitral institutions, is among those steps which have been taken. The legal setup has also been improved. Now it's good to hear, I think it was quite interesting to hear this morning that we will now have a hearing centre, which is, I think, another good step forward. I think it has to be said that the signature of the Mauritius Convention is also going to have, although it is not, this one is treaty-based, and although what we are doing here is not treaty-based, but I'm sure one can certainly link to the other. Now, so much therefore for the case of Mauritius as a place for regional arbitration. Let me now come to Dirk Bukowski. Now, Dirk, I understand, is going to address us on investment arbitration in Africa. And my understanding is that there is certainly not enough of this on the continent. So I suppose it's going to be quite enlightening to hear what Dirk has to tell us. So Dirk, the floor is all yours.
Honourable Minister, thank you very much for this very kind and generous introduction. And I will try to confine my remarks indeed to the frame that you've set out. I think you very aptly described my project today. Honourable Ministers, Honourable Attorney General, Honourable Under Secretary for Legal Affairs of the Nations, Honourable Chairman of UNCITRAL, Excellencies, distinguished ladies and gentlemen. I'm here from the Permanent Court of Arbitration, whose name has been mentioned a few times today. And the creation of our institution is best understood in the context of a 19th century trend, namely to involve third parties, neutral third parties, in the settlement of international disputes. It's in this context that in 1899, a new institutional arrangement was reinvented as perhaps the most tangible result of the Hague Peace Conference, the Permanent Court of Arbitration. The Permanent Court of Arbitration is, until this date, an intergovernmental organization that serves as a permanent framework for dispute settlement. Now, you'll be glad to hear that the PCA has, in the past century, brushed off some of the dust that you can still see on that picture, and turned into a modern arbitral institution. And while the Peace Palace in The Hague still serves as our emblematic headquarters, we have also decidedly moved into the 21st century, if not beyond, by setting up office in a place called Cyber City. Now, the caseload has become a lot more diverse since the original days. While the PCA was originally established to deal with disputes between states, you can see that state-state arbitrations with 6 pending cases are actually now, at least numerically speaking, a minority of what the PCA does on a daily basis. Most of our cases are investor-state arbitrations. I might add as a footnote of perhaps some interest to the Mauritian audience in the room that 3 of these investor-state arbitrations currently pending have been initiated by Mauritian companies, and 2 of the 32 contract-based arbitrations against states have been initiated by Mauritian companies against African states. The main reason why I'm showing you this docket is that this trend, this caseload, is actually intimately related to the organization whose work we celebrate today, UNCITRAL. The great majority of the PCA's cases, including virtually all of the investor-state arbitrations that are pending, follow the rules of procedure of UNCITRAL. In fact, the PCA has nowadays established itself by quite a margin as the preferred institution for administering UNCITRAL proceedings, with over 50 such cases pending at the moment, and over 110 or so cases in total. The PCA's close ties with UNCITRAL are, in fact, manifest in the rules of procedure of UNCITRAL, which refer to the Secretary General of the PCA various places, including when it comes to the appointment of arbitrators or for keeping checks on tribunal fees. So, given these close ties, it's a particular pleasure for me today, on the PCA's behalf, to congratulate UNCITRAL and the Mauritian government to have been able to carry this process for the adoption of the Mauritius Convention so far. Now, this has been a somewhat lengthy introduction for taking a closer look at the universe of the kind of cases that I've just looked at, the universe of investment arbitration, and in particular a geographic subset of these cases, namely the African region. So when I speak about investment arbitration in a wide sense, I have the following 3 scenarios in mind. And I'll be very brief on these. These are all actual PCA cases to make it a little bit more, a little bit less abstract. Of course, there are contract-based cases, and here's one involving a United States investor and an African government for the refurbishment of a power plant. A lot of things went wrong, I won't go into details, but of course the power plant was not functional in the way that it should be at the end of that process, and that led to arbitration. The other category that we mentioned is treaty-based arbitrations. Now, I was going to mention, in fact, a case brought by one of the Mauritian entities against an Asian government as a more typical case. The reason I chose this one is actually for 2 side aspects that will be of interest for us today. This is the arbitration mentioned earlier, brought by the Philip Morris Company against the government of Australia, challenging, essentially, plain packaging for cigarettes, and in particular the intellectual property aspect of that, namely that Philip Morris is no longer able to deploy its trademarks on the packaging. I don't want to go into the substance of that case, but rather point out 2 aspects that are quite interesting for our topic, developing a regional arbitration destination or venue for investor-state arbitration. And There was quite an argument in this case, and all of that is public because it's parties agreed to disclosure of these procedural orders on the PCA's website. Quite an argument about the place of arbitration. Essentially, the tribunal was called to make a choice between London and Singapore. And if you look at the tribunal's decision, interestingly, the proximity of evidence is one of the aspects, but the existence of a host country agreement, in this case with Singapore, was considered to be a decisive factor in favor of choosing Singapore as the place of arbitration. Now, we envisage, of course, with Mauritius having a similar, in fact, a stronger host country agreement in place with the PCA, that similar arguments would be made by tribunals in favor of Mauritius as a place of arbitration. The other aspect is precisely the aspect of transparency. It may be interesting to note that in this case, a number of documents are public by agreement of the parties, and there's a fairly sophisticated mechanism set out in Procedural Order Number 5, available on the PCA's website, that explains which documents are available under which conditions. Now, in this case, the parties voluntarily adopted that regime and submitted certain questions to the tribunal's decision, but this is the kind of regime, I suggest, that could well be adopted by a tribunal in applying the rules of trial transparency rules. So if you're looking for guidance as to how that would look like, it might be one place to go. The final case to describe the universe, the case that we're looking at, is actually a slightly unusual one, namely an investment case, but brought by one state against another state, here the government of Ecuador against the government of the United States. It concerned the question as to how particular treaty provisions should be interpreted. It's a relatively rare scenario, these state-to-state cases, but they do form part of the larger universe. Now, how does that universe of disputes break down geographically? And we've heard some initial figures in the speeches of the Honourable Minister this morning. And I'd like to give you a little bit more detail on that. Well, first of all, looking at just the PCA cases, it's clear that cases involving Africa are on the rise. But let's look at it in more detail, and I give you some PCA statistics to start. African cases currently represent 16% of our docket. So this excludes the Middle Eastern figures, which ICSID would include in its statistics. If you would include those, you'd probably get around 20%. ICSID figures have evolved very slightly in the past months, but we still get to over 25% of cases involving Sub-Saharan Africa, North Africa, and the Middle East. In 2014 only, 21% of all cases were Sub-Saharan African. So brought against governments from Sub-Saharan Africa challenging African policy measures or administrative action. So the conclusion is very clear. African governments' problems, as it were, are very much a topic of investment proceedings today. Now, as we've also heard, and I can be brief on that because that figure has been discussed before, only around 6%, and that's the PCA figure, of all arbitrators are of African nationality. In ICSID, we have a breakdown of, again, 6%, 2% only from Sub-Saharan Africa. And one scholar has looked at this in some further detail and looked at the CVs of those arbitrators appointed in the ICSID proceedings, and has concluded that even among the 6%, less than half actually practice in Africa. So the access, the hurdle to break into the investment arbitration market, as it were, for especially Sub-Saharan African arbitrators seems to be extremely high. I've also tried to get some more information on hearing venues. I certainly had a chance to look at the figures of the PCA. I've also spoken on an informal basis to colleagues at ICSID in that regard. In both cases, I have a confirmed number of 3 hearings held in Africa, but that out of the total number of investment cases that are pending makes a very low single-digit percentage figure, probably lower than 2% of all hearings that are held in Africa. Now, looking at the development of international law, of international law for the protection of foreigners from a historical perspective, it is not at all a foregone conclusion that things had to look that way today. Of course, the international standard for protecting foreigners has been contested around since the early 20th century. Attempts to codify that standard in the 1930s at the League of Nations Codification Conference failed. There is a fairly famous pronouncement by the American Mexican Claims Commission in the so-called NEAR case, which does set out a international standard that's still cited today by arbitral tribunals. But interestingly, if you look at it from a historical perspective, as soon as that standard was announced by the Claims Commission, what followed was a Latin American riposte, of course in the form of the revival of the so-called Calvo Doctrine, named after the prominent Argentinian jurist Carlos Calvo. And that doctrine stated in a nutshell that disputes with foreigners should be resolved according to national law and in the local courts. Now, what's interesting here is both positions of that discussion came together in a new global forum after World War II, the United Nations. And it was here the principle of permanent sovereignty over natural resources that was the catchy battle call really at the General Assembly and resulted in a number of landmark resolutions, including Resolution 1803, which I have here on the screen, and the so-called Charter of Economic Rights and Duties of States. What's interesting is that newly independent African states at that time were leading voices in that debate at the UN. So Africa was directly engaged at the highest government level and shaped the international law rules applicable to foreign direct investment, including rules, as it were, for dispute settlement. And the voting record is very clear. If you look at Resolution 1803, South Africa was the only African country that voted against that resolution. All other African countries at that time, members of the United Nations, voted in favor. If you look at the Charter of Economic Rights and Duties of States, all African states voted in favor of that resolution. And I've gone through the General Assembly records leading up to that vote, and it's clearly the case that Africa was engaged. This was not just a vote where the button was pressed, but there are numerous statements from heads of state on the record where this development was endorsed. So what happened? Why the apparent disengagement today of Africa from the investment arbitration system? I can only speculate about the reasons for the relative absence of an African voice today. One explanation may lie in the fact that today's investment arbitration system largely emerged from another competing forum, the World Bank. As you know, that is the forum where the ICSID Convention was elaborated. Another factor that may have had a role to play was the shift from the rather engaging frame of permanent sovereignty to a seemingly much more technical language of economic cooperation as we find it today in trade and investment treaties. And finally, one may assume or speculate that the use of an arbitration mechanism that resembled in many ways what we know from the system of commercial arbitration may have given those regions where commercial arbitration is widely practiced a certain first mover advantage in the game. Be that as it may, there are good reasons for Africa today to take ownership of the investment arbitration system, and I'm not going to repeat what Ministers Badin and Minister Sinatombu have said so well earlier. Of course, the economic benefits or cost benefits for users in the region, economic benefits for the country hosting proceedings, more profoundly, the strengthening of the rule of law, and more generally, perhaps, the imbalance that has to be addressed. In addressing this imbalance, I think one can look at it through along three vectors. There needs to be a legal ecosystem in place for arbitration to thrive. We need an infrastructural ecosystem, and we need training. And I can be very brief on these points because Duncan Batchel has actually covered them very well on the example of Mauritius. So I will really refer to what he has already told us. The legal ecosystem, actually, I think it's fair to conclude, in Mauritius, is in place to support an extensive and mature arbitral practice, including potentially in respect of investment arbitration. I might just drop a footnote on the PCA's function here. As Duncan has noted, PCA is endowed in the Mauritian Act with certain functions that are often endowed to courts in other jurisdictions, functions relating to the appointment process notably. And if you look at the travaux préparatoires, it's very clear that the Mauritian legislator wanted to attribute these functions to the PCA as a respected international institution in order to assure international users that the system here would function according to international standards without any surprises. And in fact, this role is not just a theoretical one. We have received a few requests under the Act, including one rather major challenge to an arbitrator, which resulted in a 5-party commercial arbitration, which resulted in a 30-page reasoned decision from the PCA's Secretary General. I also do not need to say a lot about the infrastructural ecosystem. There's of course room for improvement, but as you can see, the basic infrastructure is around in Mauritius. We have in fact held one hearing as the PCA involving an African company in an African state in this very hotel, the conference room right next door, and it worked very well. Nevertheless, I can only second Duncan's thoughts that a dedicated hearing centre would make it much more credible for Mauritius, for us to market Mauritius internationally. I also won't add much on the training front, but rather move directly to my concluding remarks, namely a broader observation on which I propose to conclude, an observation on the ultimate goal that such training should have. And I'm thinking here specifically about investment arbitration. I think in the end, any procedural expertise must dovetail with increased knowledge of the substance of international investment law. And in other words, and I'm borrowing here the title of an article by an eminent arbitration practitioner, the goal is to empower African states to make meaningful promises to foreigners. Investment law has increasingly come under fire for some of the substantive and procedural options it is regarded as providing. And to mention only a few particularly contentious ones, there is, of course, the vague wording of treaties, the effect of so-called umbrella clauses that elevate contractual promises to treaty promises, the extension of most favored nation guarantees to procedural questions, lack of transparency, conduct of arbitrators in council. In many cases, such concerns might be avoided had the treaty been drafted differently, and the authority and power to decide what goes in the investment treaty is reserved to government. UN's Economic Commission for Africa, UNCTAD and other organizations have set up programs recently to assist developing countries in understanding the more subtle aspects of the commitments that they have made. And the PCA's own outreach, notably through the Mauritius office here, is intended to complement these initiatives at the procedural level. So to address the imbalances that the statistics so painfully highlight, I'm very confident that the Transparency Registry will be a most valuable tool in these outreach efforts. Thank you very much for your attention.
Thank you very much to both Duncan and Dirk for their interesting and enlightening presentations. When we look at those two presentations together, on the one hand, I think we have all heard about the efforts of Mauritius to sort of get onto the arbitration agenda. And on the other hand, when we hear Dirk, he mentioned something which I think must be highlighted, which is the apparent disengagement of Africa and why we should take ownership of investment arbitration. Now, that leads me to wonder whether, when you speak of one country trying to sort of climb up the ladders of the arbitration agenda, you take steps the PCO involvement, we engage with the LCIA, we get the International Arbitration Act, we get the judges. There is actually an obligation, if I recall properly, from the Supreme Court of Mauritius to consider sending the parties to mediation. If the court thinks that this could help settle the issue. Now these are the steps taken. Now when we speak of disengagement of Africa, although we're speaking of treaty-based sort of arbitrage, is it disengagement or is it exclusion? Is a question I put to myself. But I am not the one to be putting questions. I will leave it to the floor. I just want this little thought to pervade in our minds, and I will therefore open the floor for questions. Yes, Mr. Moulin.
Again, perhaps to get the debate going, if I may answer your question, I would answer unequivocally, exclusion. One can trace the historical reasons as to why it has happened, but that is what it is. I'm not saying it's exclusion by states. Of course, it's a deliberate ploy of states, but it is an exclusion by certainly the commercial arbitration community, because it's nice business and you keep it. And I would refer back to the reasons why we have this international arbitration project in Mauritius, because we thought we had enough of all this talk in conferences and people saying, oh, inclusive legitimacy, etc., etc. What was being done about it? Absolutely nothing. Which is why, I think Africa has to take it in its own hands to get back in the scene and to become, as the title of Dirk is putting it, owners of the system again. But once this effort is made, what is very interesting is that you find it's a two-way street. Because in fact, many do want to come. And there I go going to the PCA, to the LCIA, to UNCITRAL, to ICSID. Once you start engaging with the institutions, telling them, actually, we have a solution, we have a starting point, they have errors. And the quid pro quo element, which has gone with formidable association with these institutions, which is that, for example, the PCA, yes, we are paying to a permanent office for a state like ours, it is off us, it doesn't come cheap. But the quid pro quo is they are training, they are meeting potential arbitrators in Africa, they're training them so that within a generation we have a good contingent of international arbitrators from Africa, not just for our MIAC hearings or PCA hearings in Mauritius, but to be used throughout the world. And that has been the philosophy underlying it. And just to give another example of that goodwill which is there, it's very good news, of course, this morning that we are going to have that hearing centre. And one further reason why it's very good news is that I know the World Bank's ICSID has been waiting for this because they want to conclude a facilities agreement for us to have on a regular basis African arbitrations, investor-state arbitrations conducted in Africa, in Mauritius.
Thank you for this observation. Any question? Well, why do you frame your question? I'll say another thing. I just now realized why I was so circumspect every time my ministry comes to me and say, sir, we've got to sign this IPPA. And I said, what is that? Because I've only been Minister of Foreign Affairs for 3 months. And now I understand, Investment Promotion and Protection Act. So this therefore seems to be the starting point of the treaty-based setup for arbitration to come into play. Now the question I'd like perhaps to raise again, pending other people putting question, is since we are speaking of treaty-based investor-state arbitration, which is where the constitutional transparency rules and today's convention, where they come into play. How realistic is it that, because in commercial arbitration, we can also agree to say that we will be governed by the constitutional rules? how realistic is it that in international contracts, international commercial contracts, that we will see the introduction, the integration of UNCITRAL transparency rules of 2013 and even the UNCITRAL convention rules of which we are signing today. To what extent would that be realistic? Would one of the speakers want to take this one or anyone else? I mean, ladies and gentlemen, it seems to be outing the questions also.
I think very briefly, we'll have to see, as the previous speaker said, but the best moment to evaluate maybe 1 year's time or a little later when we have some practice on the rules. There is, of course, the rules are designed at this stage to refer to a treaty-based arbitration, as you rightly say. To the extent that the new version of the UNCITRAL rules apply and disputes are initiated after a critical date, the rules will apply automatically. So there's no need to agree specifically on their application. The convention has the beauty of doing that, having that effect in respect of disputes at an earlier time. But we're still talking, as you say, about treaty-based disputes. Now, as far as contract-based disputes is concerned, nothing would preempt the parties from agreeing on a similar confidentiality regime. They could even copy and paste much of what is in the confidentiality rules, the transparency rules. I've also seen cases where both parties recognized the need for some level of transparency while protecting confidential information, but weren't quite able to agree what exactly the strictures should be. So in those cases, the parties have sometimes submitted that dispute to the tribunal and authorized by that agreement the tribunal to put in place the transparency/confidentiality regime that it deemed most appropriate. And that certainly is a way that's open under commercial arbitration. Commercial arbitrations, notably under the UNCITRAL rules.
I can perhaps add one concrete example, picking up on Celine Moulin's comments, and particularly on Dirk's presentation. And that is that, and I should acknowledge that we are joined by the distinguished representatives of the People's Republic of China, to whom this example partly relates. When I went to Kenya, I was referred to an example of an old case. This is going back some way, but it was given to me by a person in Kenya who wanted to illustrate the problems that there can be of a contract between the Kenyan government and a Chinese contractor for the building of a railway. That contract provided, a railway in Kenya, I should say. That contract provided for the disputes under that contract to be resolved with the governing law being Chinese law and the language of any dispute resolution proceedings being Chinese. Now this picks up on what Dirk was saying about education and increasing awareness of issues that can arise in dispute resolution. It's not only a matter of training arbitrators and training lawyers to represent parties. It's a question of training everybody so that they go into negotiations of contracts and other treaties with their eyes open and the awareness of what might happen, what will happen if a dispute arises, and that they think about the consequences of that. It may be that, had they thought about it, they still would have agreed to arbitration in China and in the Chinese language. But they said to me that it was fairly clear when the dispute arose that nobody had given this thought before. So there was consternation about the fact that no Kenyan lawyer could be appointed to act in the language of the arbitration because there wasn't one who was considered suitable and who spoke Chinese. And that the arbitration would be held in China. And that it would be governed by a law that Kenyan lawyers wouldn't feel able to engage with. So I'm not saying there's a right or wrong answer to where proceedings should happen. What I'm saying is that when negotiating treaties and contracts, countries need to be very much alive to what will happen if there's a dispute and to give it serious thought rather than leaving it until later. That's a significant benefit of the kind of education that I believe we are talking about, and it prevents exclusion. But that's just one example, and as I said with the greatest of deference.
I think I just got another point to make the case for Mauritius. My second secretaries at the Ministry of Foreign Affairs speak very good Mandarin. So next time that they need someone, we can have some good Chinese-speaking people to make the arbitrage. Ladies and gentlemen, we have reached 3:15, which means that this panel is now over, and we do thank both Duncan Bagshaw and Podkowski for having managed to keep us awake after the nice lunch that has been offered to us. I do, however, want to make a point that we must agree that there is a real need for growth in the practice of international arbitration in Africa. I do hope that this remains a very live issue in everyone's mind and that we can all work together in that direction. Of course, hoping that when growth occurs in the practice of international arbitration in Africa, that we will try to remember to give Mauritius a small share of that place. So thank you very much for your attention, and we'll hand over to the next panel. Thank you.
Honourable Ministers, Excellencies, distinguished delegates, ladies and gentlemen, before introducing our panelists and giving them the floor, I thought I might give you a hands-on short description of how, to take the title from our panel, how the law of arbitration is developed at international level. But in a very pragmatic sense, what is it we actually do at UNCITRAL? A report from the front, as it were. So, just so you understand and try to picture what it is we do, UNCITRAL is a commission of the United Nations. The way we work is you are in the plenary format of the United Nations system, so that if you imagine when you've seen on TV the General Assembly room and all the flags of the UN and all the delegations of the UN states and all the delegations, that's exactly the format we work in. Now I should say, when I took the chairmanship of the Commission and the working group, I was told, you will be sitting in that room and that's why I did it. But then of course they went and had works there, so I should never do it. Thank you very much. We have 16 member states of UNCITRAL that rotate every 3 years. You are a member for 6 years. But this is actually pretty much irrelevant because all other states of the UN system are observer states, and we do not make any distinction in our working methods between member states and observer states. So that, and very, very importantly, our method of work is to reach consensus. We take no votes, we don't call for indicative votes, we don't do any of this. We have the possibility of doing it, but it never happens. I think it's happened once, and I think it's a fantastic tale of irony. The vote was taken about the methods of work. So there you go, but never a vote on substance at UNCITRAL. Of course, that makes at times for a very painful process. If you can't have a vote, you need to keep working until you do reach a consensus, and you can have a significant minority, I would say 6 or 7 countries can block consensus if they want to do so. That can be painful. In this particular project of the transparency rules and the transparency convention, this was particularly acute because UNCITRAL is very much used to doing technical work, drafting legal text, drafting the best possible legal text, finding legal solutions to practical problems. Whereas this work had a dimension which was quite political, and that became apparent very early on. Why? I think you've heard it today. Because this was the first time that the investor-state dispute settlement system was being discussed in a plenary forum of the United Nations. So that you had a number of states that came there to vent their anger, to vent their complaints about matters which in fact were not related to what it is we were trying to do, and often forgetting the essential point, which is that actually what was being done was to alleviate the cause of those complaints, not make them worse. But we had to deal with it. And I think for all those reasons, it was all the more important that a full debate be had on the complaints that we brought, even if you showed that they were irrelevant. and a successful outcome reached. I think that the consequences of not reaching a solution are not to be underestimated. And so that conclusion happily happened, and that is why we're all here today. And I think that highlights the importance of that method of work, of your picturing that room, of all those states coming together into what really are multilateral negotiations between all the UN member states, so that the rules which are the Anti-Fraud Transparency Rules of 2014, the convention which is about to be signed today, are actually, I venture to say, a universal standard. They really represent the result of 4 years of consensus work of all the states of the UN system. Now I'm delighted to have with me today two speakers who have been very closely indeed associated with that multilateral negotiation process that's led to the convention. Shane Spedici is currently counsel at the Trade Law Bureau at the Department of Foreign Affairs, Trade and Development of Canada. At the Trade Law Bureau, he is responsible for representing the Government of Canada in investor-state arbitrations brought against it under Canada's investment treaties. In addition, he provides legal counsel and advice to the Government of Canada during the negotiation of international investment agreements. Since 2008, Shane has also been Canada's delegate at UNCITRAL, where he has participated in the revisions of UNCITRAL arbitration rules, as well as to the development of both the UNCITRAL rules on transparency and on today's convention. Again, trying to bring you back to that negotiating room, Shane was always my first port of call. When everybody was shy of taking the mic because they had nasty things to say, one could rely on Shane. Dan McGraw to my left is President Emeritus of CIEL, the Center for International Environmental Law in Washington, D.C. and Geneva. He teaches international environmental law at Johns Hopkins University and human rights and environment at the University of Miami. Professor McGraw has served in the United States government under the past 4 presidents. He's on the board of directors of a publicly traded corporation and on the boards of directors or advisors of several environmental and human rights organizations. He has served as an arbitrator and participated as an active observer in the negotiations of the Anti-Fraud Transparency Rules and Conventions from their inception. Now, it's important to understand that CIEL was actually one of the prime movers of what has now become the Anti-Fraud Transparency regime. They started the debate within the reform of the arbitration rules and ultimately carried their voice through to the debates on the actual transparency instruments. And we've always had, I say so respectfully, fantastic interventions from Dan, but I would say equally importantly, Dan very quickly learned when not to speak. When negotiations were getting very difficult with our way through. So without further ado, I will now give the floor to Shane.
Well, thank you, Salim, for the kind words and the introduction. I think because it's getting near the end of the day and we're getting near the end of this process, time to tell a little bit of a story about Salim as it is at UNCITRAL. Salim, as people know, chaired the working group through all of these difficult negotiations for us. And each time he was elected, he had a habit of getting up and saying, let's just get down to business. I'd like to dispense with all the formalities and the thank yous and the congratulations, and I'd like just to get down to it. Now that was quite useful in the UNCITRAL working group. It saved us a morning usually of sort of the typical niceties. But I think the time has come to break that rule, because the time has come to say thank you to Salim for his chairmanship, and the time has come to congratulate him for, I think, what he has been able to accomplish here, because without his leadership, I don't think we would be where we are today. So, Salim, thank you. And there is another person that I'd like to acknowledge, and she's sitting in the back over there, Madame Montanari. was the secretary through the difficult time, there was a person who was more essential to our work at UNCITRAL. I don't know who it is. I think that without her assistance, we could never have developed the carefully crafted and deliberative standards that we have. So I want to say thank you to her as well. We've heard much about the convention that we're here to sign today, and I do believe that it is one of the most important conventions that has been developed. We've heard a lot about what it contains, and let me just emphasize, it's important not only what it just accomplishes, but also its approach. It is an innovative convention, and it is something for UNCITRAL to be proud of. In this sense, though, it represents just yet another one of the developments that UNCITRAL can take pride in, that the United Nations system can take pride in the development of arbitration. That's what I've been asked to talk about this afternoon, the role of the United Nations in this field. Of course, the history of arbitration, the history goes back quite far, hundreds of years back. We've heard about some of that today, but I don't propose to take us on a history lesson back through all of this. I'd like to focus more on what the UN's contributions have been in the field of disputes between states and private individuals. And here I think the Honourable Minister of Foreign Affairs was saying earlier, it's challenging to speak near the end of the day because often everything has already been said, but I think that's also one of the advantages, and the advantage we can take at UNCITRAL. Salim was telling you about the process where we have a plenary session and states raise their flags and speak. One of the advantages of going near the end of those discussions is you can just raise your flag and say, I agree with everything that's been said before me. And so I think I'll take that advantage now. For numerous times as I was able to do during UNCITRAL, I agree entirely with what my distinguished colleagues have said about the convention and what we're doing here today and about investor-state arbitration in general. But I do want to go back and talk a little bit about the history and how we ended up here, but I don't want it to just be a history lesson. Instead, I want to touch on why it is that I think UNCITRAL and the UN has been able to enjoy the success that it has, and why it can be continued to position to continue that success into the future. And we've heard today from James and from Gabrielle also, it's a future with challenges. It's a future where the system that we're talking about today has been and is subject to scrutiny and criticism. The convention is an important step. The convention we're here to sign today is an important step in addressing a lot of that criticism, but certainly not the last step we're going to have to take. So as we talk about what the UN has done and its accomplishments in the past, let's keep in mind how those past successes and understand how we can reach similar accomplishments in the future. So let's go back, and we'll talk about, very briefly, some of the first developments in this field of investor-state arbitration. The first bilateral investment treaties that contemplated investor-state arbitration come in the 1950s. Of course, individual treaties with arbitration clauses would have met with limited success if it weren't for one crucial development by the United Nations. We've heard a little bit about it earlier today. It was the New York Convention. The primary problem with obtaining an arbitration award is actually enforcing it. The New York Convention, which was developed again by the UN and opened for signature in 1958, solved that problem by creating a presumption that arbitral awards would be enforceable in the parties, subject to limited exceptions. What this convention did was give arbitration teeth to ensure that its bite mattered. And today there are over 150 parties to the New York Convention. This convention is really one of the foundations of our current system of international investment arbitration. And we have the developments and the hard work of the people at the UN and the Secretariat to thank. Importantly, what I'm focusing on here is that the New York Convention really marked the beginning of a period where we saw rapid growth in the idea of arbitration as a way to resolve disputes between states and private individuals, investors. And a rapid growth, anyways, in the development of international investment treaties, and at least the idea, if not quite yet the practice, of international arbitration. So what do you have going on in this period? At the same time, roughly, that the New York Convention is being negotiated, the OECD is also developing its draft convention for the protection of foreign property. This comes out in 1962, and it's the basis for thousands of bilateral investment treaties that have been concluded over the next few decades. At the same time, you have the World Bank, which is one of the specialized agencies of the United Nations, embarking on another project that we've heard about today, the ICSID Convention. And this ICSID Convention, which provided a forum for the settlement of investment disputes, but also streamlined procedures on enforceability of awards, is another one of the foundational pillars of our international system of international investment arbitration. Again, from a specialized agency, the United Nations. There are 150 states that are parties to the ICSID Convention, including, happily I can say, finally Canada. So together with the New York Convention, these are the two fundamental treaties that make our system the way it is today. But the contributions that the United Nations and UNCTAD made did not stop there. In addition to giving us these treaties, it's given us some of the primary rules for the procedure of arbitrations. You heard her speaking about them just a few minutes ago, the UNCTAD arbitration rules. These arbitration rules were originally conceived of to be commercial arbitration rules. They were picked up because of the carefulness with which they were drafted. They were used in international investment treaties by states. And they have become one of the sets of primary rules in interstate arbitrations today. You had the UNCTAD model that UNCTAD developed, and which was widely adopted by states across the world as a basis for their own domestic rules on how they would treat international arbitration. And so by the turn of the century, you've got the UN, either through UNCTAD or specialized agencies of the World Bank, giving us the tools to create a functioning and modern system of international investment and dispute resolution. In fact, I think it's fair to say that far from just contributing to the development of arbitration, as the title of my presentation suggests, I think it's fair to say that the UN provided us the very foundation for this area of the law. Perhaps that's a good point to stop and take stock of where we were around the turn of the most recent century. There were a network, and you've heard, of about 3,000 bilateral investment and multilateral investment treaties, providing both protection of foreign investments and the ability of investors and states to resolve their disputes peacefully through the use of international arbitration. Now, this network of treaties was a significant accomplishment, but certainly around the turn of the century, we get a growing amount of discontent amongst certain stakeholders, with some, even many aspects of the regime. And we've heard today talk about how one of the particular areas of criticism was that these tribunals were, using the quote, secret, and that they were conducting their arbitrations, making their decisions out of the public eye. Well, in 2010, UNCTAD, as it had in so many challenges over the past years in the arbitration field, took up that challenge and they developed the rules that we are talking about today, rules on transparency that are implemented for existing treaties for the Mauritius Convention. James has gone through them in detail, and I won't bother to do so, but these rules are a high standard set of rules, and I think Salim is right when saying that they are a universal standard now, adopted by consensus. And important amongst that, and it's been mentioned several times today, is a repository function that the member states have asked UNCTAD to perform. Because collecting this information into one place is a key part of what we're trying to do with transparency. But we've heard also about the elephant that was in the room after we developed those rules on transparency. And that was all these existing treaties. And I think this is where I want to pause and talk about the unique opportunity that UNCTAD presents as a forum for resolving problems of this kind, and for the ability that it does to help us offer further reforms and further innovations in this field. Because UNCTAD is a forum where governments, member states of the United Nations gather regularly in one spot and work together on the basis of consensus to harmonize and further develop the state of trade law. Now, that is an exceptional accomplishment to be able to do. And what did it allow UNCTAD to do? It allowed us to propose essentially one solution to the Mauritius Convention to 3,000 problems. That's incredible. It's an accomplishment. And as I said, this is an important step to addressing some of the criticisms, and James has talked about it a little bit as well. But there are many other criticisms that are prevalent, and we heard about some of them today, including codes of conduct, arbitrators really independent. These problems, if tried to be solved on a bilateral or individual treaty basis, are very difficult because there are so many treaties the states have to be able to commit the resources. But what UNCITRAL will do, whether it's for future treaties in offering us deliberative, careful thought on model clauses, on potentially codes of conduct, on ways forward when we're negotiating further treaties, or whether it's with an innovative convention like this, reaching back to fix a problem that there was consensus needed to be fixed, but couldn't be fixed as a matter of practical realities on an individual basis. That's what UNCITRAL does. And so when we look back and we see clearly how the UN has played such a foundational role in developing the current system of international arbitration, we should also take satisfaction in what has been accomplished. But I think we should also look forward as well, to take part into what still can be done. Because while the challenges that face this system are significant, UNCITRAL and the United Nations continue to offer us the opportunity to build on and develop the existing foundation we have and to make it one that truly reflects the realities that we live in the 21st century. Thank you.
Thank you, Shane. Dan will now address the relevance of transparency in setting up dispute settlement mechanisms.
Thank you very much, Salim. It's a great pleasure to be here. I want to thank the Mauritian government for being a leader in taking on this convention. It's a great meeting, and it's great to have all of you here. I also wanted to thank Salim and Corinne for their absolutely valuable leadership in bringing the rules and the convention into existence, but that's already been done, so I will break from convention and thank their parents. I earlier met Salim's father, who was here. I don't know if he's still here, but anyway, they did a very good job, and so I'm going to just extend thanks to you and forego thanking Corinne and Salim personally. I'm either the last speaker before the signature, the last speaker of the day, or I'm the first speaker before the signature. The last speaker of the day, of course, we want to get to the signing, and I don't blame you, you've heard a lot of speakers. I tried to find some transparency jokes, but it turns out there are none. I Googled, did all sorts of things. I asked people, but I couldn't find a transparency joke. If you know of one, please let me know for my future, or maybe during the question and answer period, you can mention it. As the first speaker before the signing, I get to look forward a little bit, and that is exciting, in fact. Before addressing my main topic, which is broader than investor-state dispute settlement, as you know, I'd like to make two preliminary points. The first is that transparency serves different values in different contexts, and thus requires different approaches in those contexts. And one also has to look at the countervailing interest as well on a contextual basis. The second point, and I'll come back to that, I want to illustrate both these points with one story. The second point is that transparency is not enough. We need other measures to accompany transparency, and I'll come to that in a way, or in a moment as well. So the story stems from the fact that I've led workshops for several governments in the Americas, in Europe, and the Middle East on transparency. And again, in keeping with the first point, we have to really find out what the governments are interested in. And the Middle Eastern government was quite interesting because what it cared about transparency in this context anyway had to do with its nuclear power program. It was interested, A, in not being confused with perhaps other countries about whether it wanted peaceful nuclear power or nuclear weapons capability. And the second, it wanted a safe nuclear program that maintained a consistent and constant source of energy. And this led essentially to 5 different types of transparency that we concerned about and that we talked about in the workshop. The first was between the government and the International Atomic Energy Agency. This required good communications, it required trust, it required accurate reporting, and it required inspections. And so you have there a very specific set of things that were directed at that type of transparency. The second was within the government, between the Nuclear Regulatory Agency and other parts of the government. The concern here was that the reporting to the IAE would be accurate and that the regulatory agency would be doing a good job domestically in terms of safety and energy supply. This required an interagency process that was robust and effective and also required reporting and other types of communications. The third was between the Nuclear Regulatory Agency and the plant operators. This required regular reporting and communications, again, accurate reporting. It required whistleblower protection, so that if someone in the plant operator, the nuclear plant operator, felt that his or her concerns were not being taken care of, they could raise those concerns both within the agency or in the operator and externally to the government and not be penalized, not be retaliated against. It also required an open and fair bidding process for plant construction and plant operating with respect to the private sector. The fourth was within the plant itself, the plant operators itself. And here, the question really had to do with the relationship between management and staff. And the goal was to make sure that management knew what was actually happening in order to be safe, in order to be able to provide accurate reporting to the Nuclear Regulatory Agency and all the way up to the IAEA. This required constructive interaction, good personnel policies generally. Again, it required whistleblower protection. It required that appointments and promotions be based on merit, not on corruption and that sort of thing. And it required conflict of interest rules within the operator. And then finally, we had between government and civil society. So we've seen government and the IAEA, within the government, between the Nuclear Regulatory Agency, the government, and the operator, within the operator itself. And now the question is the government and civil society. And it's been clear historically that this sort of operation needs input from civil society. And have civil society be a watchdog, but in this country this was challenging because there was no history of a robust civil society that could perform the job. So what we decided instead was to form an international advisory board to make up for this challenging situation. It is chaired by Hans Blix, who was the chair of the IAEA, and has other people on it who believe in nuclear power and want it to work, but don't have to make their reputations. They already have reputations. So we did the best we could in that respect. But the basic messages of this story are two, again. First, that when you think about transparency, we have to really be context specific and think very carefully what are the interests that could be served, what are we trying to accomplish, and then to try to adopt solutions with respect to transparency that fit that. And again, there's the countervailing side too. What are the downsides of transparency with respect to a particular situation? And with respect to those downsides, by the way, we haven't talked a lot about those today. Some of the earlier speakers mentioned the need for confidential business information, the need to make sure that an arbitral process or other international dispute settlement process functions well. So those have to be identified and taken into account. I won't say anything more about them, but they're very important, obviously. So in terms of international dispute settlement, it means, besides identifying those countervailing interests, we have to see, well, what in a particular dispute settlement mechanism, what are the interests that can be served by transparency. And previous speakers have begun to talk about that. I'll come back to that in a second. The UNCITRAL transparency rules represent an extremely careful effort, and I think a very productive and constructive outcome in terms of doing exactly that process. And this was the most, I was in the government, U.S. government for 10 years. I was on scores of U.S. delegations. I led some U.S. delegations. This was the most careful negotiation that I have been privileged to be part of. And so I think we can be very happy about these rules. Again, the second message is transparency is not enough. If we look at the nuclear power situation, we can see we need international safety standards, we need an inspection system, we need communication and reporting requirements, we need domestic safety laws on how the nuclear plant has to be run and how the waste has to be disposed of. We need domestic whistleblower, anti-corruption, and conflict of interest laws. We need trained personnel, as was mentioned earlier about the arbitrators, and again, internal conflict of interest rules within institutions, within the operators, for example. And with respect to the international dispute settlement mechanisms, we need similar kinds of things. We need well-qualified judges and arbitrators. We need effective codes of ethics, which unfortunately often don't exist. We need means of publicizing, such as the UNCITRAL registry with respect to the UNCITRAL rules. And also the PCA has recently put online a very good webpage that I recommend you look at. And last but not least, we need rules, effective balanced rules about transparency and public participation. So turning to those now, let me just say my topic is the relevance to setting up a international dispute settlement mechanism. And the most obvious point there, which I need to make, is it's best to do that at the beginning. It's best to think about transparency and public participation at the beginning. There are at least three reasons for this. One is that then that can be easily matched, or at least carefully matched, with other interests that are being served by that mechanism. The second is that we can avoid confronting accumulated bureaucratic intransigence, if you will, that people just don't want to change and they're afraid the system seems to work. Let's not mess with something that really isn't broken. And we had to overcome that with respect to the UNCITRAL rules. We had to overcome that before that to fix it, and that's an ongoing issue. So it's better to do it early if you can, and of course it's just cheaper and easier to do it at the beginning. Having said that, we're in a situation where there are many international dispute settlement mechanisms that exist already, and almost all of them have significant rule of law deficits. So let me just name two. And these are not criticisms, these are just pointing out challenges that it would be good to deal with in terms of transparency. First, if we look at the International Court of Justice. International Court of Justice publishes the briefs of the parties, but only the day of the argument. So there's no way to know beforehand, unless you somehow get an illicit copy, what's actually going to be argued and what the facts asserted are and that sort of thing. The ICJ does allow amicus briefs for advisory opinions, but not for contentious opinions. And even for the advisory opinions, when an amicus brief is submitted, it's not put into the official record. So people looking at it later can't see, oh, well, the WHO argued this about tobacco or what have you, previously, the example that Gabrielle mentioned earlier. Again, not criticizing the ICJ, I'm just saying that there are things that can be improved about transparency. But the PCA is the same, Permanent Court of Arbitration. It doesn't have a mandate to promote transparency. It is doing some things like the webpage that I just mentioned that are admirable. But in fact, most of those cases are very hard to understand from from the outside and with the problems that leads to. This leads to the question of why do we care about transparency? And we've already heard a lot of reasons about that today. I'm not going to go through all of those in detail. I will mention what I think are the main categories, and if I missed any, please just mention that later. And then I'll pause on one to close with this list. The first is the human rights values that transparency provides. Now, this is not discretionary, actually. When the UN is involved, as UNCITRAL is, or when a state is involved, states have obligations to protect human rights. The UN, in its preamble in Article 1, emphasizes the importance of human rights. This is not like the other policy arguments I'm going to make. And if we take the Mauritius Convention and the UNCITRAL rules, they're a way that states can realize that human right obligation, or those human rights obligations: access to information, access to justice, participation. And they're an easy way, actually. As it was pointed out, this convention allows states to do this quite easily with respect to investor-state dispute settlement. In terms of non-legal but still important policy reasons to have transparency, and again, this is at a general matter, I can't go into all these different institutions, of course. But we heard from the minister about the importance of transparency for promoting political integrity and accountability. There's accuracy and fairness of decisions. If the public knows about what's going on, it can correct factual misstatements by one of the parties. It can add new legal arguments. It can add new perspectives. And I can tell from personal experience this happens. In the U.S. Supreme Court, I represented the families of the hostages who were taken back in the late 1970s, and there was an argument that neither the federal government or the plaintiff in the case would raise, and I raised it, and that's the ground that the Supreme Court used, and that was in an amicus brief. So this can happen. It doesn't happen all the time, but it can happen, and when it is relevant, it's an important thing for an arbitral tribunal or a court to have access to that information. Security. This wasn't mentioned publicly or by the speakers, but the Finnish ambassador said, transparency helps security. The more we have to hide, the less secure we are. And I think that's true individually, as corporations, and for both societies. Transparency increases the credibility and legitimacy of the particular investment state, or international dispute settlement mechanism involved. And here, let me just recount a conversation I had with the chair of the dispute appellate body at the World Trade Organization, which was very confidential, if you want, secretive, if you want, my kind of terminology. Until they started opening up some things. And he said this was great inside the WTO because most countries hadn't been able to, they hadn't been party to any kind of dispute, so they didn't know what was happening. Even for the parties to the WTO, it was a black box. And once they were able to actually see what was going on, well, they said, well, that's good, this is a good system. And it's true for the NGOs too. I mean, as James was saying, if you don't know what's going on, it's probably best actually to assume the worst. I don't know if you play poker, but the rule in poker is the dealer always cheats. Right? I mean, if you don't follow that rule, you're not going to be successful. And so, of course, NGOs are going to assume bad things are happening, etc. So the more we know, the better the credibility and legitimacy of the particular mechanism involved. It can promote social and environmental responsibility for other actors, not states, but if corporations are involved, for example. The minister mentioned this morning. And finally, this is the point I want to pause on before I close. It can promote coherency within the international legal system. Now, we haven't really talked about that much. Gabrielle mentioned, well, there are conflicting decisions. There are inconsistent decisions within the investor-state dispute settlement. We can call it regime, although it's many, many regimes, as you know. So, in theory, as you know, in the international legal system, there is no such thing as stare decisis. Tribunals are not bound by the legal rulings of other preceding or contemporaneous tribunals. And now, Albert Einstein is supposed to have said, I don't know if he actually said this, that in theory and practice are the same. In practice, they're not the same. And that's what we find here. In practice, we see a much more nuanced approach that looks a lot like stare decisis in a variety of contexts. I'm going to mention 5 of those. The first, and this is very clear, is when the system itself provides for stare decisis, either implicitly or explicitly. So if we look at the World Trade Organization, we have dispute settlement panels, and then there's the appellate body. And the appellate body has made it very clear that it's going to reverse any panel that doesn't follow its previous rulings. Now this, it seems very obvious that if you have a system like that, that has to be the rule, but that is stare decisis without any question. You also find that kind of result within particular international dispute settlement mechanisms. So the World Court, the ICJ, is famous for following its own decisions. It goes out of its way to make sure that it doesn't conflict with a previous World Court decision. Now again, this makes intuitive sense, but it looks a lot like stare decisis, although in theory stare decisis doesn't exist. It also occurs where different mechanisms are interpreting the same instrument, the same legal instrument. And so an example there are the NAFTA cases, where they're different dispute settlement panels, but they're interpreting the same legal instrument, that is the NAFTA, the North American Agreement on Free Trade. And so they try very hard to be consistent within that system. Again, understandable. It gets a little more interesting, however, from here on out, where you have different mechanisms, and they're interpreting different instruments of the same general type. So we have, 3,200 bilateral investment treaties or investment chapters in trade agreements. What we see is that the panels under different treaties, and in theory they're all different, right? They use similar language, not always identical language, but you see the panels are referring to one another. And they're trying to be consistent, including by differentiating sometimes. They'll say, well, this is different than that case, even though that case is under a different treaty altogether. That doesn't solve the fact that there are inconsistent opinions. If you look at the cases against Mexico involving their tax on high fructose corn syrup, there are 3 opinions. No 2 of them are consistent. And there are other examples too. James said, well, the economist should have mentioned problems. Well, most of us know about some of these problems anyway. We don't know about all of them because some of the cases, of course, are secret. We don't know about those cases, but we do know about some of the problems. It gets even more interesting when you're having, and that's true in the human rights system too, by the way. You have the African human rights tribunals refer to cases from the European Court of Human Rights and the Inter-American Commission, or usually the Inter-American Court of Human Rights. So you have these references across systems. They're interpreting different legal instruments, although they're legal instruments of the same type. And then finally, we see situations where we have different mechanisms interpreting different legal instruments that aren't the same type. And this, of course, is most interesting, controversial, and we could talk all day about it, but you see this in human rights cases and in WTO cases. So in the shrimp turtle case, the WTO was confronted with the question, well, what to do about U.S. unilateral, if you will, laws that are intended to protect sea turtles beyond the U.S. territorial jurisdiction. And it looked to a multilateral environmental agreement see how sea turtles should be considered. And we see the same thing in human rights, although there it's even more controversial to me because they look to multilateral agreements that the party to the case before them is not a party to, if you follow that. So they're applying either multilateral environmental agreements or other, not even always binding agreements, declarations that the country is not legally bound to follow. Now, why do they do this? Right? I mean, this looks a lot like stare decisis in a way, right? Why do they do it? Well, it increases consistency among cases, it increases accuracy. And the World Trade Organization is not institutionally competent to think about sea turtles and how, whether they're endangered or not around the world. So it looks to an institution that is. And overall, they increase coherency. But in order for that to happen, you need to be able to see these cases. They have to be open, they have to be public, they have to be transparent. And it's not just enough to see the outcome. One really needs, good lawyers will know, and one needs to see the kinds of arguments that were made, the kind of facts that were made, and you're going to be able to distinguish them from that sort of thing. So this is just one of many reasons that we want transparency, but it's obviously an important one. So in conclusion, let me just say it's critically important that international dispute mechanisms of all types provide for transparency. The details will differ, but the basic idea that transparency and public participation should be allowed for. At present, however, most have a rule of law deficit in terms of transparency and public participation. These deficits should be remedied as soon as carefully possible. Carefully relates to the fact that one really has to look at the context and take that into account. Some of the reasons to do this are policy-based, including promoting corporate responsibility, political integrity and accountability, security, accuracy of decision-making, credibility and legitimacy of the mechanism involved, and the coherency of the international legal system. But there's also a very powerful legal reason to do it, and that is international human rights, and all countries are bound by them, and that's really not discretionary. The Mauritius Convention on Transparency provides a very convenient way to fulfill these human rights obligations in the context of investor-state dispute settlement. Moreover, I'm sure that this convention embodies a paradigm shift, and that it will cast its light of transparency far beyond the investor-state context. We are fortunate indeed to be able to be here for this signing. It's very exciting, and it's historic, and of course then we have to implement it well, and that will also be an exciting process. I want to thank you all for being here, and thank you very much.
Thank you very much. We started a bit early, so I think what we'll do is aim to conclude this session at 4:30, which leaves about 20 minutes for questions and answers. So I now ask for questions or interventions from the floor. Mr. Bukowski.
Thank you very much for this very interesting insight into the genesis of the convention. I was hoping we might be able to reflect a little bit on something that has already come up earlier today, namely where to go from here. And I'm not so much thinking about should we develop an even more ambitious convention, or what are we doing to get the signatures and then the ratifications in, but rather what are we doing with all the information that is going to be made available under the convention. And the reason I put the question is, as Professor McGraw has said, everything, all information is relevant only in a particular context. One example where everyone knew how the information was relevant to stakeholders was when the BCA broadcast the award rendering ceremony for the RBA arbitration, fixing essentially the boundary lines for the RBA region. You could exactly see on our own list of provided by the service provider, the number of hits you got from Sudan, from Addis Ababa, from New York, and the stakeholders in the region and internationally. Now that's less clear in international investment disputes, for example. One public arbitration is a case against the government of Canada, where we have on the PCA's website 8 days worth of video material. That's very valuable information in a way, but it requires some translation effort to make that formal transparency, which exists in this case, a true valuable asset to public academic. And I think as arbitral institutions, our hands are somewhat bound here, because of course it's not our job to interpret what either the tribunals or the parties have done. Who's the right translator to make that, to add that link to the chain and connect really the investment arbitration world and the public at large?
Thank you very much. So if I understand your question correctly, one could say basically how does one convert the formal mechanism into a practical benefit, effectively? Shane, do you have to say that?
Well, I'm not sure I can help that. I would say I thought my remarks at that hearing that Dirk was talking about were totally clear and didn't need any translation whatsoever. But no, I think that's a good question that's being talked about, and one has to understand in the context of transparency, because it's certainly a highly technical area of law, and I think one thing for us to be cognizant of, we've been doing these open hearings for a while in the after context, and what we typically find is that we have relatively good attendance on the first day, and then people realize that it's not quite as exciting as what they see on TV, and then the attendance dwindles, and by the end of your 8 days, you don't have many people watching anymore. I think that's part of the nature of just the reality of legal practice, but I also think that it is a highly technical area of the law, and so having this outreach for people to have education, understand what is happening and what is being done is important. Now, is it the job of the creators of that information, the states, the parties, to really do so? I'm not sure that it is. I think that our obligation here is to give access to that information. At that point, there will be specialists or a specialist has already been helped to interpret that information for the public in a way that is more manageable. Certainly there will be a significant volume of information to put out, but I think this comes a little bit back to the question that was asked earlier, was is there sort of favors, is favor investors, is favor states? I think the answer is no, it favors the public, and it favors the system. Is the system going to need help in sort of interpreting and sifting through some of this? Probably, but we're at the beginning of this process, and I would fully expect that help to come, that help to arise, and certainly there will be, I'm sure, growing pains as we do this. This is a paradigm shift, is what Dan is saying, but I think that it will be there, and that efforts can be made to make this useful way to the public in trying to understand what is actually happening in these sorts of disputes.
Actually, I think Dirk was sat next to Dan, because that seems to me a question planted by Dan. Because of course, that's his stock in trade. He is the translator. Can you tell us about that?
Well, thank you. I didn't plant that question, but two types of answers. First, in response to what Shane said, in our hemisphere, governments have more than an obligation, human rights obligation, to provide effective access. In some situations, governments have the responsibility to proactively provide information. It's not clear where the line is, but the case, the first case about this was a Chilean case, Claude Reyes versus Chile, and it was an investment information case, and it specifically said the government had an obligation to provide the information. It wasn't just to make it available if someone were to request it. So that's part of the answer. And I don't know about Africa or Europe in terms of your regional human rights jurisprudence. I think It varies, really. If the information is understandable and discloses corporate misbehavior, for example, I would think stockholders would say something. And maybe in our country, the SEC, the Securities Exchange Commission, would say something. If it has to do with government misbehavior, and all of these, of course, allege that the government has violated international law. That is part of the case. Except maybe some of the contract cases, in which case it's a contractual obligation. But otherwise, these are international law standards that are being allegedly violated. Then you could have a popular kind of political response. If the question, if you want to think about the coherency of the international legal system, I think it's going to be probably the organized bar, and particularly the organized arbitration bar that looks at these and says, whoops, there's a trend here that's interesting, or there are inconsistencies, etc. So I think it'll require a number of different translators, and it's a very good question. Thank you.
Thank you very much. Let me just add to that before giving the floor to Ms. Montineri. I was being flippant, of course, but it is a fact that at the moment, pragmatically, institutions like CL, like IISD, have in fact been the translators of a lot of that information, because they have the technical ability to understand what's coming from those hearings, which most of our citizens would not. So that even if we were, most of us, of course it's not my field of law, but otherwise if we were to sit and just listen to an investment arbitration hearing and the finer points of fair and equitable treatment are being discussed, or even worse procedural aspects of a most favored nation clause, of course everybody will be lost. So I think pragmatically at the moment there isn't that deficit because we have those institutions, but it raises a bigger issue, which is those institutions of course have their particular angles, and so they should. And I for one would hope that with the dissemination of the information you will have more applicants, more groups like that, which will represent particular interests, which will have the ability to understand and then bring their own voices to the debate in a way which ultimately will take time, will represent the global, more global civil society. Corinne?
Yes, thank you for giving me the floor. I'd just like to make a brief comment following the presentation by Dan Marco. And it's just to highlight the multifaceted aspect of that convention on transparency. Because it not only deals with transparency, and transparency is an important value, and I think Mr. Margory showed very well that transparency, as we conceive it in the convention, may have an impact on the proceedings in other models. It has already an impact on commercial arbitration, as we see more and more questions about whether arbitration should remain confidential, to which extent they should be transparent, and so there are some discussions at the moment on that. So on the substance, transparency is of course key for reinforcing democratic processes in countries, so it's a very important value which is brought by the convention. But the convention also has a mechanism in itself which is extremely innovative. But the mechanism of the reservations and so on that we have in the convention, and which are quite unique, as my colleague from the treaty section sitting just right next to me can explain further. This convention will potentially reform the existing investment treaties, the 3,000 existing investment treaties. And there were meetings 2 weeks ago, one in Geneva and one in Paris very recently, by the United Nations Conference on Trade and Development, another one by the OECD, where they were really thinking about how shall we proceed to reform investment, not investment arbitration. And then also investment arbitration. And they were all mentioning and I am quoting the Mauritius Convention on Transparency. And they were all thinking, well, we need to really think about that convention and see to which extent we can use it in other models to reform the current system of investment that is currently set up by the treaties and the investment arbitration. Thank you.
Thank you very much, Corinne. I think that is important information. Further questions from the floor? I can't see anything at the moment, but to think about further questions, we still have some more time. In the meantime, perhaps I will ask this, which to an extent follows through from what
Corinne has just said. We heard from James this morning that once he has perhaps to take stock, to give time for this instrument, inshallah, to be successful. And then think about how we can use it, but obviously within Antitrust and in cooperation with other institutions, the OECD, UNCTAD, ICSID, the PCA, we have been starting to think about the extent to which this convention provides a useful precedent going forward. And by that I mean, let me perhaps explain the technical way in which this convention works. It's not very complex at all, in fact. All we are doing is using a provision of the Vienna Convention on the Law of Treaties that provides that where you have two treaties which are successive in time and which cover the same area, as you would expect, if there is a conflict, then the later in time will prevail there. That's the basic rule, of course, it's more complex than that. And so what we are doing is you have investment arbitration mechanisms which are a unilateral offer in an investment treaty. So the way an investment treaty works is Madagascar and Mauritius sign this treaty. Mauritius investor invests in Madagascar. It doesn't have to do anything formal. It's simply, once that treaty has been signed, is enforced, does something in Madagascar, builds warehouses, has a business. Something happens which it says is a breach of the standards under the treaty. So that could be, the basic example is an expropriation. And then the Mauritius investor will sue Madagascar, and the innovation, of course, of investment treaties is get sued directly. Before you had to ask your state to espouse your claim, you would get diplomatic protection sometimes, and then it would be a state-to-state dispute. This is a direct dispute between the investor and the state. Now, the model for these arbitrations has been commercial arbitration, which is why it was all secret, because commercial arbitration is confidential. So now we want to introduce transparency in that. How do we do it? Are we going to ask states to enter into bilateral negotiations, 3,000 sets of bilateral negotiations, in order to do that, or is there another mechanism? And the other mechanism was to use that provision of the Vienna Convention on the Law of Treaties to say, let's just do a multilateral convention open for ratification by all states, the effect of which will be that if both states to the convention, if both states to the bilateral investment treaty are also ratifying states to the convention, that will be the later rule in time. So you no longer have a confidential regime, the default regime under the anti-fraud rules and other rules, but you now have a transparent regime. That's how it works. Now the question then becomes, can that be used, that mechanism of a later treaty in time, multilateral, be used to reform wider issues? Of course, the big question is, going back to what Dan was saying about stare decisis, that you do have decisions which are inconsistent. And within the current system, we do not have a way of resolving those inconsistencies. So should we, for example, that's the most extreme example, there are many other problems that might be resolved in that way. Should we have a multilateral convention creating an adequate mechanism? So, and I would like to ask, of course, starting with our speakers on the panel, what they think the way forward is in that, and then if anybody on the floor has any opinions about perhaps James, I'm here as well, and others. So Shane, what would you say?
Well, I think on some of these questions, this is clearly some of what I've literature. There's lots of areas of criticism, and it's really the pellet mechanism is one, and what you have seen in certain international treaties is at least a commitment to examine the possibility of doing an appellate mechanism. And nothing really firm has happened on that front, but there has certainly been a lot of interest, and I know that there's been more and more events where this is being discussed as to whether or not there should be an appellate mechanism. Could a multilateral treaty effectively establish an appellate mechanism? We've had multilateral negotiations on an agreement on investment before, and they didn't go so well, mildly. So I think when one looks at the way the system can be reformed, sometimes the only way forward does appear to be a multilateral way, because it's the only way you can address multiple treaties at one time. On other aspects, though, I think it's a difficult question that's going to depend really on most of the applicant member states of places like the United Nations to do that, but also on more technical questions that may relate to real questions of international law. What can you do within a successive treaty? How far can you take a successive treaty in terms of changing the original terms of the treaty without getting into other questions of what else we do to the treaty? And I think that the real sort of difficult international legal issues that will have to be looked at. I think that part of what Corinne is saying is that people are starting to think it's time to start looking at all of those questions.
Thank you very much. What I hear is pragmatic issues, of course, but also perhaps legal issues as to that particular article in the Vienna Convention.
We've seen in the World Trade Organization how important the appellate mechanism is. It has really imposed discipline on the panels, and it's come out with rulings that then have to be followed that are sensible in terms of interpreting the WTO agreements and are workable, and also to some degree, to take into account other interests better than the panels were doing by themselves. There's a major difference, of course, and that is that there's one set of WTO agreements and there are 3,200 bilateral investment treaties, as we talked about. And I think the legal issues, there are legal issues, I think they're tractable. I think they could be dealt with. I think there would be some benefits to having an appellate mechanism. I have not yet worked out in my own mind what an appellate mechanism would do in terms of having so many treaties that use similar or identical language, since each one, in theory, really represents the intentions and the consent of the two countries involved, which could be using the words differently, same words differently than two other countries did. There are practical issues in that sense that I think they're practical. I don't think they're legal issues, but I just haven't had a chance to think through. But I'd like to think that this would work, and I think it would work in terms of a multilateral approach like the Mauritius Convention. I don't see that that's impossible.
Thank you very much. Anybody from the floor? Yes.
Thank you, Mr. Chairman. It's not a question, it's just a kind of remark because we are close to the end of the conference and it is in respect of the convention as such. So the question could be what is the future of the convention? And I think that the convention is very, very, very important for the investment world. And purposely it's using the word investment world, not investment reputation. Because in any case it is important for the investment reputation. But the whole investment, once the investment world or the world of investment, once the convention will enter into force, and I believe that it will be relatively soon, then the investors on one side, meaning also stakeholders who are behind the investment, and the governments on the other side, will start to think from the very beginning of the investment about the provision of the convention and the rules of transparency. So this might be significant for the future in respect of the convention. And being very much linked to UNCITRAL, I would like to underline how important it was during these 3, 4, 5 years, if we take into account also transparency rules and the work of the convention itself, that we were very, very, very faithful to one of the most prominent principles for the work of UNCITRAL, and that is to reach consensus. And I think this is also one of the values which goes together with this convention. And another remark, I think the convention could contribute to the development of international arbitration and investment arbitration at international level and also at regional level. Because investments could be focused in a region. There are certainly more investments in one region within, so investors and states would belong to the same region. Therefore, I think convention, the transparency rules give a chance for let's say, for development of international relation at regional level as well. Thank you very much.
Thank you very much. James, did you want to say anything on the academic mechanism? You don't need to. Yes. Could we give the mic to Mr. Costello? Yeah.
Well, Dan ended his comment on a practical note, and I would just add one other practical note, because I too have not formed a view about whether a new appellate mechanism is either viable from the standpoint that you mentioned from the convention, or whether it is really ultimately a net gain for the system. I think there are a lot of complaints already that investor-state arbitration has become a very lengthy and expensive process, both for the investors but also for the states. And so if we add another layer of appellate review, even if it were only optional, you can imagine that it will soon become the norm, that nothing will be final until there has been an appellate review. And that promises to drag out these disputes even longer and make them more expensive. And so we need to keep that into account. Are the possible benefits of bringing more uniformity to decisions in this area? Do they outweigh possible risks of making it really an even more burdensome system?
Thank you very much. While you have the mic, don't go, because I wanted to ask you one last question, which is, I heard Dan basically playing on the gauntlet, I thought earlier, and saying Mr. He didn't say it in those terms, he never would, but Mr. Costello eluded the problem when he said, well, the criticism is coming because we're having discussions about things we don't know. And he said, I quote, "We do know the problems, Mr. Costello." Do we know the problems?
Well, I guess my point is, yes, in the sense that there are decisions out there which organizations like Dan's organization would say are a mistake. In other words, awards by investor-state tribunals that some people would say are a mistake. When Dan says, well, we know it, the question is who's the we? I think there would be a disagreement among many different people about which decisions in each person's judgment were wrong. But I guess the important point is we need to have that debate about the actual decisions, and transparency is a very important tool in making that debate possible. And once we have the debate about the actual decisions and the actual outcomes of the investor-state dispute resolution system, then I think we have a much better debate. We're much closer to being able to reach a kind of a consensus through the UNCITRAL type of process about what needs to be reformed and what doesn't need to be reformed. The point I was trying to make is I think the debate up until now, in the context of these three pending multilateral treaties, has been somewhat disappointing because it hasn't focused on all these facts.
Thank you very much. I think that's a nice note to finish on. So I would simply ask you to express your appreciation for our speakers in the usual way. Thank you very much, Dan. And so that concludes our conference program. We'll have the signature ceremony starting at 5:15. And I look forward to seeing you then.
So we are now going to proceed with the signing ceremony, and historical moment indeed. Before the signing ceremony for the Mauritius Convergence and Transparency, I have the pleasure to invite distinguished representatives of states
and regional economic integration organizations to make statements. Let me first invite the distinguished representative of Canada, His Excellency Gaston Barbon, High Commissioner of Canada to the Republic of South Africa.
Honorable members, Undersecretary General, Excellencies, Ambassadors, High Commissioners, distinguished delegates, our dear Mauritian hosts, Mesdames et Messieurs. I am the first speaker, so I promise to be brief, not to set a standard for brevity, but rather to give scope to the others, to say more positive things than I will say about the Mauritius Convention in my short remarks. Donc je suis très content d'être ici au nom du gouvernement du Canada pour signer cette convention aujourd'hui. The Mauritius Convention represents one of the most significant innovations in the field of investor-state dispute settlement in years. This convention, once widely adopted by states, will enhance transparency in investor-state arbitrations under thousands of existing treaties. Canada has long been recognized as a global leader on transparency in investor-state arbitration, and I am proud to acknowledge the role that Canada had in assisting in the development of both the UN Convention on Transparency and Treaty-Based Investor-State Arbitration and on the rules of transparency. Le Canada est vraiment heureux d'être parmi les premiers pays de signer cette importante convention. Voilà, bref compromis. Thank you very much.
Thank you very much. I have now the pleasure to invite the distinguished representative of Finland, His Excellency Mr. Petri Salo, Ambassador of Finland to South Africa, Botswana, Lesotho and Mauritius.
Honourable Ministers, Honourable Undersecretary General, Honourable Chair of UNCITRAL, Excellencies, ladies and gentlemen. Investment, in other words capital, is a vital production factor for economic activity, which in turn is a prerequisite of development. Investment protection treaties are seen mainly from kind of the negative point of view, that they're protecting against something bad, but they should be seen also in the positive manner of promotion of investments. Notably, they play this role for the small and medium-sized enterprises, which in most countries do provide the majority of jobs and innovations. We have heard today in the very interesting and valuable contributions that transparency in arbitration on investment treaties, if not provides, but at least promotes, and probably already provides, better respect on human rights in issues of lawmaking or treaties related to trade and investment. It provides, or transparency promotes accountability and really also security, and not only to private actors but also to states or state authorities. Philip Toes has such an important implementation of the antitrust rules of transparency in all disputes related to investment protection agreements, notably in the current state of affairs, where arbitration is facing some harsh public criticism. From the beginning of the process, Finland was one of the most active and important promoters and developers of these rules of transparency. And we want to emphasize our commitment and readiness to follow these rules of transparency by signing the convention today in Port Louis. In addition, we encourage all countries to sign the treaty at the earliest convenience. Thank you.
Thank you very much. Je souhaiterais maintenant inviter le représentant distingué de la France, son Excellence, Monsieur Laurent Vernier, ambassadeur de la République française auprès de la République de Maurice.
Monsieur le sous-secrétaire général, messieurs les ministres, mesdames et messieurs les membres du corps diplomatique, mesdames et messieurs, la transparence est particulièrement nécessaire dans le cadre de l'arbitrage visant à régler les différends entre les investisseurs et les États. Elle est en effet garante de l'information des citoyens, indispensable lorsque les intérêts publics sont en jeu. C'est parce que nous sommes persuadés qu'il s'agit là d'un sujet essentiel que la France s'est beaucoup impliquée dans la rédaction puis l'adoption du règlement sur la transparence en 2013. L'applicabilité du règlement au seul traité futur nous semblait cependant en deçà de la volonté de renforcer la transparence dans l'arbitrage d'investissement. Compte tenu du très grand nombre de traités relatifs aux investissements en vigueur, les efforts déployés auraient en effet pu sembler vains. La Convention de Maurice, que nous avons l'honneur de signer aujourd'hui, permet potentiellement d'étendre les règles de transparence aux milliers d'accords existants, et elle est pour cette raison d'une grande importance. La France est un État membre de l'Union européenne et partage donc un certain nombre de compétences avec elle, notamment en matière d'investissement. Et donc c'est évidemment dans le respect de ce partage des compétences que la France entend appliquer la Convention de transparence de la CNIL. Elle pourrait donc être amenée à préciser au moment du dépôt de son instrument de ratification comment elle entend appliquer la Convention de transparence, en particulier pour le traité sur la charte de l'énergie. Je saisis cette occasion pour féliciter chaleureusement Sally Moulal en tant que présidente du groupe de travail sur l'arbitrage de la CNUTSI pour son rôle durant les négociations ayant conduit à la conclusion de la Convention. Félicitations d'autant plus chaleureuses que la France a eu la chance de le compter parmi ses plus brillants étudiants. Je vous remercie.
Je vous remercie. I have now the pleasure to call the distinguished relative of Germany, His Excellency Mr. Konrad Schachinger, Permanent Representative of the Federal Republic of Germany to the Office of the United Nations and other international organizations in Vienna.
Honorable Minister, Honorable Attorney General, Honorable Undersecretary General, Honorable Chair of UNCITRAL, dear colleagues, distinguished delegates, ladies and gentlemen. The Federal Republic of Germany welcomes the adoption of the United Nations Convention on Transparency in Treaty-Based Investor-State Arbitration by the United Nations General Assembly and is pleased to sign the convention at today's ceremony here in Port Louis, Mauritius. Together with the rules on transparency, the convention contributes to the enhancement of transparency in state-based investor-state arbitration.
and to the dissemination of knowledge about peaceful dispute resolution schemes. If widely adopted, the Convention has the potential to significantly reform the way investor-state arbitrations are conducted and address concerns that important matters of public interest are being resolved behind closed doors. The Convention is thus also an important signal for more transparency and rule of law. Germany has been actively engaged in the elaboration of the Convention throughout the sessions of the Institutional Working Group in Vienna and New York. I think this is the appropriate moment to thank UNCITRAL for providing a framework for negotiating successfully this convention, and also the opportunity to thank the chair of Working Group 2 for his able and wise guidance, and also thank the staff of UNCITRAL for the permanent support of our endeavors. For Germany, as a major exporting nation, predictability, transparency, and reliability in transport investments is of utmost importance. Of the globally existing 3,000 bilateral and multilateral investment treaties currently in force, Germany has concluded 129, out of which 85 provide for investor-state arbitration, to which the Mauritius Convention could apply in the future. On the occasion of today's signing of the United Nations Convention on Transparency in Treaty-Based Investor-State Arbitration, I have the honor to state on behalf of the Federal Republic of Germany that Germany reserves the right to formulate a reservation with regard to the application of the Convention to the Energy Charter Treaty. In concluding my statement, let me thank the government of the Republic of Mauritius for organizing and hosting this signature conference here on this wonderful island. I would also like to express my thanks to the government and people of Mauritius for the extraordinary hospitality and overall friendliness extended to me and all foreign participants. Thank you very much.
Thank you very much. I have the pleasure now to invite the distinguished representative of Sweden, His Excellency Mr. Lars Jonas, Ambassador of Sweden to the Republic of Mauritius.
Honourable Minister of Foreign Affairs, Regional Integration and International Trade, Honourable Minister for Financial Services and Good Governance, the Honourable Attorney General, Undersecretary General of Legal Affairs of the Legal Council of the United Nations, Ambassador, ladies and gentlemen, may I say all protocols observed. The Government of Sweden welcomes the decision by the UN General Assembly to adopt the UN Convention on Transparency in Treaty-Based Investor-State Arbitration. We believe that the Convention constitutes an important step towards greater transparency and public insight into investment protection and into investor-state dispute settlement. Sweden has taken an active part in drafting the UN Transparency Rule and the Convention. And in signing the Convention today, Sweden confirms its commitment to increased transparency and reforms in the field of investment protection and investor-state dispute settlement. May I say that Sweden has a long tradition of emphasizing the value of openness. We believe in open societies. Sweden has entered into 63 bilateral investment protection agreement, which may provide a basis for dispute settlement. And we hope that this convention will lead to the broad application of the transparency rules. Finally, and on behalf of my government, I wish to extend our appreciation to the government of Mauritius for hosting this occasion and in providing the venue for this signature ceremony, or what is aptly called the Mauritius Convention on Transparency. I thank you.
Thank you very much. I would like now to welcome the distinguished representative of the United Kingdom, His Excellency Mr. Jonathan Drew, High Commissioner of the United Kingdom to the Republic of Mauritius.
Minister, Honourable Attorney General, Under Secretary General, members of the Diplomatic Corps, distinguished guests. I'm delighted that the UK government is amongst the very first to sign this important convention, which improves transparency in a critical area. The convention will open up ISDS investment arbitration courts to much greater public scrutiny. The UK wants to give particular thanks to UNCITRAL and to Mauritius for its international leadership in both driving the convention forward and, of course, hosting its signing today. Like the UK, we know many others in the international community are fully committed to increasing transparency in international arbitration. And it's very welcome to see, and I'm afraid I am going to name you all, France, Germany, Sweden, Finland, Canada, the US, and of course our host Mauritius signing here today. And we encourage all of the UK's international trade and investment partners to sign this convention at the earliest opportunity. There has been increasing public unease in the UK, in Europe, and elsewhere about the secrecy surrounding ISDS arbitration. And it's important to note, therefore, that crucially, the new rules in this convention can be backdated, so that investment agreements signed before the 1st of April 2014 are in scope, including the UK's 94 bilateral investment treaties. The new arrangements will mean that ISDS hearings, which some critics have dubbed secret courts, can be open to the public. It will be compulsory to make key documents relating to the arbitration available. It will also be obligatory for tribunal arbitrators to consider material amicus briefs submitted by third parties or non-disputing parties, including evidence from campaigning organisations. As some of you present today may know, the Transatlantic Trade and Investment Partnership, or TTIP, currently being negotiated between the EU and the US, is expected to include these new ISDS transparency rules. The UK supports this inclusion at a very minimum. We are currently working with the EU to find ways to tighten up the ISDS provision that will be included in TTIP to minimise the risk of abuse. I would like to end by reiterating the significance of the greater transparency this new convention brings to all international investment agreements. This focus on transparency has been, of course, very clear in the new financial world order that we have seen taken place in the last few years. So, UNCITRAL and Mauritius, once again, our thanks are due to you for bringing this historic convention to fruition. Thank you.
Thank you very much. I am now inviting the distinguished representative of the United States of America, Her Excellency Miss Sharon Villarosa, Ambassador to the Republic of Mauritius and the Seychelles.
I'm delighted to be here, and again, I wish to thank the government of Mauritius, and represented by the very honorable Foreign Minister, as well as the UN, represented by the Undersecretary for Legal Affairs and the Chairman of UNCITRAL, for organizing and arranging this momentous occasion. And to bring important attention to the importance of transparency and highlighting Mauritius' leading role in this. The United States is very pleased, and I, as a representative of the United States government, will be signing this convention among other countries. And as my good friend Jonathan just mentioned, there's a number of us signing today, but I think it's also very important that other nations join us in this effort, not only nations, but also regional economic organizations. Because these are very important transparency measures that will be provided through this convention. These measures will help build public confidence in the arbitration process by ensuring documents are published online, by giving interested third parties opportunities to submit their view, and overall enable both public and governments to monitor how investment treaties are being interpreted. Again, we would like very much to thank the UNCITRAL Secretariat, and I would like to give special recognition to Corinne Montineri for all of her many long hours ensuring the negotiation success. I would also like to thank Salim Moulam, the delegate from Mauritius, who chaired the UNCITRAL working group. His leadership moved the process forward at a very remarkable pace. Less than 13 days of negotiations for the convention itself. This must be an all-time record. He ensured that the convention we are signing today is of the very highest quality, both in terms of substance and draftsmanship. And he very much inspired all the negotiators by introducing opera and poetry to the proceedings to keep people moving along. This convention represents UNCITRAL's work at its best, bringing together lawyers from different legal cultures to work together to develop an instrument that will improve arbitration to the benefit of governments and the broad public in countries around the world. The United States very much looks forward to working together with all of you and many others to promote this convention more broadly and to increase transparency in investor-state arbitration. Thank you.
Thank you very much. This ends the statements by representatives of states. We now are going to hear a statement from the distinguished representative of the European Union, Mr. Ando Del Aricha.
Ministers, representatives of the United Nations, colleagues of the diplomatic corps, delegates, members of the press, ladies and gentlemen, all protocol observed. As the representative of the European Union and on behalf of Commissioner Cecilia Malmström, I would like to thank the Republic of Mauritius and the United Nations for the invitation to attend the opening conference and assembly ceremony of the Mauritius Convention on Transparency in treaty-based investors-to-state dispute settlement. The purpose of today's event is to celebrate transparency in ISDS, and the Mauritius Convention will make it possible to extend the application of the UN CITRA transparency rules to the existing 3,000 investment agreements signed before the 1st of April 2014. With the Mauritius Convention, and we salute the fact that it's called the Mauritius Convention, Minister, as you were saying this morning, it demonstrates, it crowns your efforts in this field. So with the Mauritius Convention and the UNC trial transparency rules, we have at our disposal all the legal instruments necessary to open hearings to the public, to allow interested parties to make submissions to the tribunal, and to make publicly available the arbitration documents in disputes under existing and future investment treaties. As the British High Commissioner was saying, the European Union has already started using these state-of-the-art transparency rules as a basis for the provisions on transparency in its trade agreements. Today, we open a new chapter in our efforts to improve the transparency of the ISDS system, and states can show their real commitment to transparency by signing the convention and applying it to all of their existing investment treaties. Unfortunately, as representatives of the European Union, are not yet in a position to sign, because despite the strong efforts of the European Union to have our internal procedure completed on time, it has not been possible to reach a decision in advance of the signing ceremony. 28 member states are made. Discussion will continue with a view of adopting the relevant decisions. Our commitment to transparency in ISDS is well known. It is an important aspect of the efforts we are currently making to reform the ISDS system by increasing its legitimacy and making it more accountable. Over the last 3 years, the EU has been instrumental in the UN in pushing the UNC trial transparency rules and initiating the Mauritius Convention. Further, to ensure a proper implementation of the transparency rules, the European Commission intends to fund the repository that will make information on ISDS cases accessible to the general public. Let me finish by congratulating UNC trial on behalf of Commissioner Malmström for the excellent work in getting us collectively to this stage, and the Republic of Mauritius for hosting this event. Rest assured that the European Union will continue to work with the goal of promoting transparency in investor-to-state dispute settlement. Thank you very much.
Thank you very much. I would like now to invite the Under-Secretary General for Legal Affairs and United Nations Legal Counsel, Mr. Miguel de Serpa Suarez, to officially open the convention for signature.
Excellences, Mesdames et Messieurs, au nom du Secrétaire général des Nations Unies, en sa qualité de dépositaire de la Convention des Nations Unies sur la transparence dans l'arbitrage entre investisseurs et États fondés sur les traités, j'ai le plaisir et l'honneur aujourd'hui de déclarer officiellement la Convention ouverte à signature. Conformément au paragraphe 1er de son article 7, la Convention est ouverte à la signature ici, à Port-Louis, le 17 mars 2015, et après cette date, au siège de l'Organisation des Nations Unies à New York. Nous allons procéder à la cérémonie de signature. Les représentants des États seront maintenant invités à signer la Convention.
I have now the pleasure to invite the Honorable Etienne Sinatandou, Minister of Foreign Affairs, Regional Integration and International Trade of the Republic of Mauritius. now the pleasure to invite the distinguished representative of Canada, His Excellency Mr. Gaston Baron, High Commissioner of Canada to the Republic of South Africa. I invite now the distinguished representative of Finland, His Excellency Mr. Petri Salo, Ambassador of Finland to South Africa, Botswana, Lesotho, and Mauritius. Nous souhaitons maintenant inviter le représentant distingué de la France, Son Excellence Monsieur Laurent Garnier, ambassadeur de la République française auprès de la République de Maurice. I would like now to invite the distinguished representative of Germany, His Excellency Mr. Konrad Scharinger, permanent representative of the Federal Republic of Germany to the Office of the United Nations and to other international organizations in Geneva. We are now inviting the distinguished representative of Sweden, His Excellency Mr. Lars Ronaz, Ambassador of Sweden to the Republic of Mauritius. We are now inviting the distinguished representative of the United Kingdom, His Excellency Mr. General Drew, High Commissioner of the United Kingdom to the Republic of Mauritius. We are now inviting the distinguished representatives of the United States, Her Excellency Ms. Shari Larosa, Ambassador to the Republic of Mauritius, at the session. Thank you very much. This now concludes the signing ceremony. To close the proceedings of the day, I would like to invite His Excellency Ambassador Dylan to join us on the podium.
Thank you, Karim. Excellencies, with the signature ceremony, we have come to the end of today's event. I know, and we all know, that it has been very hectic since morning, but very fruitful deliberations. We take this opportunity to thank all of you for your participation to this historic event, and we look forward to cooperating further in this field. Excellencies, those delegates who are leaving tonight, we wish you a happy journey. And to those who are staying, we also wish them a happy and enjoyable stay in Mauritius. Thank you very much. Just to remind you that on behalf of the Honorable Minister of Foreign Affairs, there will be a reception just outside the conference room at 7. So you are all invited. It has been a pleasure to be with you all of us. Thank you very much.